Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning, everyone. Here we are early today because there will be a lot of drama today. We're going to see how much outside that courthouse, because we know we have CPU Tommy, Tom CPU, but that's not his handle, CPU Tommy, Tommy Rosa, who's been streaming outside the courthouse because today is the first day, really, that people have really learned about the buffer zone, and that even though the buffer zone exists, according to the First Circuit that made Judge Beverly Cannoni amend her order, you are allowed to be in that buffer zone as long as you don't impede the sidewalk travel, the pedestrian travel, you don't impede the witnesses, and of course you have to have an intent to try to do some harm to justice, right? You have to have that intent to interfere with justice, to interfere with jurors, or to interfere with witnesses, or whatever, to interfere with the system. So that is always something that's most difficult to prove. So we're not sure if Tommy is actually. I think we heard last he was talking to somebody on the street there, and so as soon as we see him moving around and showing us what's happening, where people are, we will go to his stream to see whether or not the state police, as you know, understand this order. Now, when he was on our show with Michael Bryan and I last night, just to serve TV, he said when he was leaving, he heard Lieutenant Hardman, who's been the person from the state police that's really been involved in all this. He's been involved in telling DeRozier to leave when Michael Bryant was walking with Scott, and then ran into Mr. Delgado and trying to do the interview as they're walking. He told Michael Bryant that he's seen him walk by 5 times and he's not to see him again. So he was obviously counting the amount of times that journalist, Justice Serve TV, was walking on the sidewalk, and suggested he couldn't be there because that was in the buffer zone. And we were on there streaming that when that happened, and got the footage of the state police ripping off a small little sticker that was on Mr. Delgado's shirt or jacket, his outer clothing, that said, it's so small, Michael said you couldn't even read it. It said something about free Karen Reed, justice for John O'Keefe. So it had everything in it. So let me just say good morning to you all. Good morning. I'm going backwards if I can. Good morning, Rhonda Hall. Thank you very much for joining us as we wait and see what's going to happen in that courtroom at 9, which should explode. John Miller, thank you very much. Lida C. Doe D said, good morning, Joseph's Cat, but I'll say good morning to you also, Louise P. Glad you're here. Threaded Needle, they're not understanding it. Yeah, that's the initial word we're getting, that they don't understand what's going on. That's why whenever you have these lawsuits for what's called a 42 USC 1983, which is a federal civil rights action, which this was, which all these suits are, they're brought under that, as they apply to the United States Constitution, to the states. It's a special way of pleading, but according to that statute, usually when you plead that, you always plead the lack of training because no one trains anybody. And we see that the training is a big deal, right? And they do not. So Oasis Cat, hi, Oasis Cat. Great songs yesterday. I know that I will have a rant at some point today, because if Judge Cannoni decides to allow the change of the Commonwealth's report, a significant change, and I'll go through that with you, in the middle of the trial, after the defense has tried it all one way, I think that, quite frankly, defense could ask for mistrial. She won't give it, but they may feel that they have the jury. They're in the courtroom with that jury every day. Why you technically can't tell what a jury is going to do, you may get a good feeling that maybe they're on your side and all by watching them, right? By watching them. I think that if they don't understand this because no one's trained them. Good morning, Mike. I hope you're having coffee out of our mug. The Alessinator, good morning. We have been calling Bob Alessi, the Alessinator, all yesterday and talking about people getting Alessinated by him. I did tell you yesterday that I thought, oh boy, I'm seeing some streaming going on. Let's say we're going to pull it in. And I do want to talk to you. Good morning, John Miller. Before, good morning, Linda. Enjoying my coffee in my JSTV mug. That is so great. You know, here we are, right? Great mug, microwave and dishwasher safe if you're really lazy like me and everything goes into the dishwasher. Hoping Judge rules Hank can't use his expert's amended report should be only decision to be made. Yeah, I'm hoping it too, because I think it's outrageous. And I can tell you why. I've got all what it means. People aren't understanding it. I think it's also, if she allows it, it's also an event that if Carrie got convicted, it would reverse. It calls it reversal. And I think that's the only thing that the judge will care about, right? So, you know, we'll see. But again, when we have time, we'll go through this all. Good morning, Law Nerd Amber. It's been 4 months already. Yeah, it's kind of like I said, Tubi's birthday was yesterday. It was 4 years, and I couldn't believe it. Time flies when we're having fun, and this community is building, and you're all finding each other and coming back to talk with each other, really. Angie Brouillard, good morning, North Carolina support here. Law Nerd Amber gifted 5 Justice Serve TV memberships. All right. Why don't we go and listen to Tommy's CPU? Let's see what's happening. He's given us permission to use his stream, and we thank him very much, Tommy DeRosier. Let's see.
Yep, to get the paddy wagon ready to go. The wagon.
Jesus Christ.
The wagon.
They've dumped off the patty. They say patty's racist, but who knows?
Oh, all right, I can see that. From a Mick.
I got yelled at from a Mick.
I'm Callahan. I'm kind of a Mick.
Yeah, so, you know, he's walking, obviously, I think, in the
I
buffer
just
zone.
don't know. Can we be filming coming through?
I'm filming.
Yeah, he's
Yep.
filming.
I am. And
Don't wanna get arrested.
I want a meeting with the dude. Meeting with.
Somebody-
How are you?
But doesn't want to get arrested.
Going in hot. Well, again, I'm here for you guys, right? I'm here for you guys. I have a camera posted on the fence railing. I just need to hit record, then I can get out of the way and it'll go. Okay?
And Tom, you were one of the guys on the lawsuit. Don't
Yeah. Yep.
you know.
Grande is gonna have to leave because Jeff Machado's here. Oh, she beeps when she goes by.
John Miller says, we don't need Tommy's CPU getting arrested. It's so funny because when Michael Bryan went up there and
Right.
said, oh, have they put the fisticuffs on you yet? You know?
Black Mercedes taking a lap. All right, well,
So what's going on with the buffer zone?
I don't know. I'm recording.
Okay, so this looks like he's at the steps of the
Just
courthouse,
find your camera.
right? That's the steps of the courthouse.
I could be. Yeah.
And as long as they're not interfering or blocking anything, I think that's the steps of
You're a
the courthouse.
citizen reporter, Tom. What are you talking about?
Yeah.
I wish
Hold on, Mike. I'm gonna go ask Mr. Hartman if he knows.
Bring the camera up. Come on, Tom, bring the camera up. Let me see where we
Oh,
are. Are we
don't
there?
film them.
Yep.
You're loud, Mike.
We are there. Okay. See, all the journalists are there. They're allowing people to go in.
Is that Karen? Yeah.
In the buffer zone.
No.
No.
And it's because of Michael Bryant and the 3 protesters, really, that this has happened. As you know, we recorded it all on the air, so there was a documentary recording that we were able to give to Mark Randazzo. As he said, Justice Serve TV, it may be small, but it's mighty. Tommy may be small, but he's mighty. And they're fearless. And they
I have to go over there.
Constitution.
Just want to double check.
Let's
Yep.
hear.
Where you going?
Let's go across the street.
Okay.
Yep.
Thanks, Tommy, for doing what you do, buddy.
Yes, sir.
So that's the
Thanks.
state trooper there.
Thanks, LT.
Still closer than it was.
Nice job, Tommy.
I'm good. All right, guys, we made it. Made it closer.
All
Was
good.
he
You know what
polite?
I need you to do? Is
Was he
my
polite?
I got my okay. Is what, Mike? I'll get it after.
Was he polite? Was he polite to you?
Yes,
Cool.
I have a camera on the stairs,
Oh.
so I'll grab it later.
No.
No,
Yeah, go grab
You
it,
can see
Tommy.
it.
Don't leave it.
See it right
Don't
here.
leave it there.
I was gonna just turn it on
Oh,
and let it run
oh.
No.
because it's already there. So
He should be allowed to stay there and film. There's no issue with regards to that, as long as he doesn't film jurors, and the jurors aren't coming in that way.
Michael, but I would.
Mike.
You probably wouldn't yell it. You want to run over and grab it? It's on. Okay.
Mike, can-
Yeah. No. Sorry.
Okay.
Sorry.
All right.
So if you're joining
Yeah, I'm
us,
good. Thank you. All
I
right.
just want to know exactly where you need to be, Tom. Like, where can I be? What can I be?
He's going.
He's gonna talk.
Yeah,
to Tom.
he's gonna come over here and talk to me specifically after,
All right.
which is all
Remember,
right.
Matt,
See, I got
Ryan said he'd do
two
that.
here, so I'm hoping I can maybe with this camera
He should be
try and get
allowed.
it better.
He should be
That's
allowed to
camera
go
2,
across the street and film.
camera
You're
0.
doing,
So
you're
I
doing
don't know
good, dude.
why.
It looks good, man.
Yeah, I'm glad he's down
I'm
here.
trying to get like a close up. I tried to get a zoom lens on it.
Don't worry about it, man. Well, today's Friday. You get that stuff. We'll get it here Monday and we'll be back.
Yeah.
You know.
I got a
Hey.
microphone I was gonna play with after this.
Do we have court TV ready to go on the monitor or what?
Yeah, they're
All right. Someone's on it.
Yep, on it.
All right.
Oh yeah, so I think Aiden's at 9 o'clock court here.
Yes.
Is down at the buffer zone. I see all you're saying.
So you can talk. You can go in the registry of deeds and use the bathroom and stuff.
Yep. I mean, they're right here.
See, before, after the new buffer zone, they weren't even allowing people there.
Here's the beautiful Jazz.
But Tom, not that I'm advising him, because I'm not advising him.
Jess Machado's here,
He should be able to.
as you can tell.
But
So we'll at least be, thank God, we'll get some legitimate content now. Thank you, Jess.
Today. For here, I'm
Yeah, you're
gonna
For Aiden. We're still gonna get good
No.
content. Thank you for tweeting, by the way.
Of course. How's everybody?
Good. Buffer zone's a little iffy. We don't know about it yet.
So yeah, where are we at with that?
Hardman asked me to stay here. He's gonna talk to me after.
Say Hardman just asked him to stay there across
Right.
the street. Okay.
Well,
It's closer than I was.
I still think you should be able to be right over there.
Oh, we agree.
Absolutely right. She's absolutely right.
Huh.
I'm not gonna
Be
push
across
today.
the street,
Right.
no
Yeah.
issues,
Yeah.
both as a
Nicer.
journalist and according to the buffer
Yeah.
zone
But
order.
I love Hardman.
Yeah.
She should be able to, I think that's a
Yeah.
violation right there, to be able to pushing him across.
So what do we call?
Jess, you know this guy here? He keeps walking back and forth
That's my opinion.
across the street in the black jacket.
You know what? I recognize him from last year.
Yes.
Yeah.
I don't know if you knew him. Okay.
No, I don't.
All right.
Camera guy?
Yep.
maybe?
I don't know if I
I
can
don't know.
message on Twitter.
Don't know.
Have we seen the reads or anybody yet?
I saw Mrs. and Mr. and Nathan.
Nathan, but we didn't.
They went in already.
Yeah.
See if I can find.
No, we have not. You think it'll be a mistrial with the Rule 14?
I
I don't put it for that.
They have to. It's so bad.
I have had a theory there would be a mistrial. I have had a theory.
Gives them time to go through all the other evidence.
For the tree. Oh, you know what? I don't see the.
8:45 to 8:50.
Her family farm.
Oh.
All right, you can hear me, Mike?
Yeah.
Say hi to Jess.
Hey, Jess.
Mikey.
Hi, Mike.
Yeah. Hey, Jesse. Good job.
Yeah. Yeah, we both like your writing.
That guy's a
Thank you.
Okay.
Just Machado, tweeted how unfair it was.
I wasn't.
One journalist seemed to have
Oh.
got press passes
Yeah.
for all 4 weeks, and everybody else, no. Okay, I'm just tweeting
I'm
him.
just rebooting. Okay. Well, that's the word. Flip has been doing an awesome job on his
I'm going
on
to
his stuff,
actually
guys.
tag Mark Randazzo. I'm sending out a tweet to Tommy CP. Tommy should be allowed to go across the street at Mark Randazzo. I think you need to ask for paragraph 5 review.
Mike with his threats is gonna get him hurt. You
Ask,
guys are fucking
ask
clowns.
Mark.
David Dijon, whatever the fuck you.
Okay, so we'll do that. I asked Mark. I tweeted at him. We'll see what that happens. Just because I think that it's wrong that they're saying he can't be across the
Yeah,
street.
I'm one of the only fucking people that fucking knew John.
Oh, we've got a few early morning curse words here. It's okay. We are a morning curse word show. We did learn yesterday, by the way. Felicia said Mark Randazzo explained the new buffer zone rules to Michael. Yes, we did a whole special interview with Mark Randazzo as he was he was going to fly to New York. He was in Vegas,
Someone's
and
gonna hurt
Michael
me,
sat
huh?
with him and said, absolutely.
Yeah,
There should be
dude.
no issue.
Fucking
Everyone should be allowed to go there and stand. They should all be allowed to go there and stand with their signs as long as they're not impeding anything or have the intent to interfere with justice. It's their intent
These
that
fucking
becomes
guys.
important. And for
Yeah,
Hardman,
I actually,
to say
hey,
you
thanks
can't
for
be,
sharing that with me about resistance to silence.
he
talking
put his
shit about
own
me.
buffer zone
But,
in effect, essentially. So I did do an at Mark Randazzo. It's up for Tommy. Obviously, he's his client. He needs to speak with him. Maybe if we get a chance, we can bring Tommy in at lunch to talk about it. Dizzy, I'm just thinking about that now, to talk about what happened here, because he's got the footage now. And now I'm sure that footage is recorded with Hardman telling him he had to go across the street. All right. There should be no issue.
Gennady!
fucking assholes.
He's smiling. Nice. He gave me a wave. He sees what's going on.
It's kind of blurry though. That's okay. It looks good.
Nice.
Yeah.
Liza.
There's Karen.
That's and again, of course, it's always this Lieutenant Hardman, right? Who's in every single one of these, including the arrest of, she wasn't arrested, but the whole Erica Walsh thing with the sweatshirts she was wearing from Microdots, Richie store, Microdots. I don't have the link right now, but I give them a shout out again. And just like we have a merch store that you all are supporting with mugs and cups, they had a merch store that had a sweatshirt on it about Norfolk being run by criminals, and so and that's what she was wearing. It had nothing to do with Karen Reed, and it was her First Amendment right to protest that by just wearing a sweatshirt or to express her First Amendment feelings, not even a protest. This is what she felt. And of course, she was told that she had to take it off walking through the buffer zone. Quite frankly, it was outrageous, right? John Miller says, don't think they should be allowed to make them cross the street. Right, I agree. They should be allowed to be anywhere in that zone as long as they're not have the intent, as long as they're not interfering and have the intent to interfere, right? And that he can ask for a review to the court. I don't know what procedures they have set up, but obviously he's got to talk to Mark Randazzo about this, because this is one of the things though that you wanted to ask. How are you interpreting this? And so he did go over there and ask. John Miller says Jessica Machado would be a good guest to have on the show. You're right. She would be a great guest to have on the show. I don't think we reached out to her yet. She's been pretty busy in that courtroom. But that's why we wanted to get on early today at 8:30 and watch what was happening there. You did see, I believe, Karen Reed coming in. Now, I don't know if we've turned the sound on off for Tommy CP, or he has the sound off for him. Okay. Tom. Oh, I see.
I said something out there, so yeah.
There
you go.
Yeah,
We just
sorry.
want to know where we can go. We don't want to have any problems.
If you guys are you trying to film right now?
Yeah, Karen's already come and gone. So.
Yeah. I mean,
Yeah.
the best spot to film is obviously across the street.
Well, no. Yeah, we're not filming. We're done with that. We just want. He said he was going to talk to Tom when he was done.
It's about where I can film and stuff like that.
All right, yeah. If
We
you'd
just
like to
don't-
speak to him,
But I mean, like,
I can tell you what I know.
all right,
Okay.
yeah.
But I know there's obviously you can film. You have the right to film, right?
Yeah.
Just go across
Across the
street.
street.
Right. Okay, so they want just
Go
on.
over here. See where these people are
I'd
standing?
love to be over
Yeah,
there.
if you'd like to go over there.
I would.
Okay.
No one's telling you can't do that.
Well, I just want to be where I'm allowed to be, whether it's over there or over there. I don't want to be over here. Right.
Appreciate that. No, I like that you guys come to talk.
Yeah.
I'm retired, so we don't want any issues.
Listen, I also have another question.
Yeah, what's going on?
On the stairs up there,
Yeah.
I left my camera this morning. I was
Okay.
going to hit film and let it run. That way I'm not even there and it captures her walking in by itself. It's on the railing.
Okay.
Can I go grab it?
We'll let you grab it in a minute. We just want to make sure everyone's in right now.
Oh,
So
obviously, yeah.
that's just one.
Yeah. But would that be acceptable if I put my camera there and let it run?
You're gonna have to talk
It's
to
a
the.
different.
But I could be down the end of the street. It's still going to record. But that's doing the same thing, the body camera. If we could get body camera footage, we could get better footage than what I could get because they got it clearer. I just get a FOIA at a time. Mikey, FOIA, we want Hartman's camera just the time that Karen come out. He's got the best footage of anybody.
Yeah, it's not a bad idea.
We
Hey,
can
something-
FOIA his camera stuff.
Tommy, something's blocking your lens.
Yeah.
Yeah, lift that up or something. I don't know what you saw. I can't see anything with that.
I'll have the same conversation. Hey, when you're done filming, I'll have a conversation with you. But you have to.
Oh, I thought we were gonna go across the street. Okay, yeah. Mikey, I gotta go black. Gonna have a conversation with the trooper.
All right, man.
I hope it's
All
recorded.
right, so hold on, all right, Mikey?
Okay.
Yep.
Hope that's being recorded because the trooper just he
All
was
right,
very,
so
this trooper
Tommy's
was
getting
like
it done.
nice and said,
Just
"Well,
so you
we
know, I gotta,
understand you can't film
I gotta text
when they're coming in." I don't
Man,
understand that at all.
Gallagher, Attorney Gallagher will be boots on the ground this Tuesday if you're looking to go down and join the crowd. She'll be down there. She's been awesome. She's been doing the circuit with all the other content creators. So yeah, Tom's down there. He is in the buffer zone where he should be. He is filming where he should be, but not completely like he had last year. But let's just be clear about that. That might change, but we're not going to push the limits here. And then someone just texted me or DM'd me from Justice Serve TV. Linda says to make sure Tom records that with Hartman. I don't know. Okay. Here we are streaming your feed. Linda says Tom should be allowed across the street, that Hartman is wrong. She said Tommy needs to talk to Mark ASAP. Okay. Yeah, I think we're going to try to get there. I have a problem with crowds, just so you know. With a lot of people around me.
We didn't lose
yeah,
Tom. He was
that's
told
my
he had to
thing.
turn off his camera to get the other camera
a
because he
whole
wouldn't be
thing.
allowed to film across the
It's,
street.
medical.
So he had to go black to do that, and he's going to talk to a
PTSD.
trooper. So that's what's going on, by the way.
So anyways, that sucks.
Right.
The fans only, hey, don't go anywhere because we're gonna have court for you here too. The fans on right now.
Yep.
I just want a big shout out for Tom. Yeah, JK. I know. Yeah, it sucks.
By the way, in Lamone Pickett,
shot
yes,
at
we
quite a
are
few
aware
times.
that Judge Cannoni was head of the committee that rewrote the rules. She actually rewrote the rules very favorable to the defense and all. By the way, so when we come back, just so you know, Felicia, by the way, Mark Rendez, as he said, explain. Let me try to show that he did explain them. It's on our Justice Serve TV. You can go look at it. It's a breakout on Justice Serve TV. If we get a chance, we'll post it. But you know, we also said Michael Bryant just said if it were him there today, he'd go with his order, have the order, and ask the troopers, how are you interpreting it? How are you interpreting this? So you don't get arrested first. Then we can go from there and all. And Michael Bryant will be there next Tuesday and Wednesday. As you know, he went to California. It was no secret. But he may do a Where Am I out there. We'll see. Because California is a big state that he's going to go out to. So I did. So that's what's going on. So now, as we go back into court, as you know, because the fan is going to be on, this whole issue about first of all, it was a really good day with the medical examiner with Alessi. He did a brilliant move. He basically got the medical examiner for the first half hour for testimony to discredit the expert from the Commonwealth that's coming, the gamma ray brain surgeon. Isak Wolf, no, she said she'd never heard of, and that you wouldn't want a neurosurgeon doing an autopsy. That's why people like my husband go to school and get residencies and internships and are board certified and take tests in forensic pathology and anatomic pathology and clinical pathology to be able to do this. They're only the medical examiner in a state is allowed to issue a manner of death certificate. A death certificate can be issued by a treating physician under normal circumstances. You're treating a patient for heart disease and they have a heart attack, that type of thing. But a death that's like John O'Keefe, that's the medical examiner's purview and parameter. And you're going to have somebody come in and from a gamma ray, I keep calling him the gamma ray surgeon from Florida because they were going to try to go around the medical examiner. But I think what happened is that Hank Brennan decided that he had to call the medical examiner, one, for two reasons, taking a lot of heat, right, about hiding things, and they couldn't afford that. But they also needed her testimony as predicate facts for their expert to opine upon in court before the jury. Okay, so I think that's that's a Dizzy. I was going to post a link to Richie's Microdot store because I talked about Erica Walsh's sweatshirt again, so I thought we'd give them a shout out, right? Oasis Cat, shouldn't MSP have their body cameras on? Can Mark Randazzo request body cameras if Tom had to turn off his camera? Yeah, I mean, I think, but do they have their body cameras on? Or do they have body cameras is the first question. Okay. But what he should request is a review of what their interpretation is, because you had Tommy being very let's face it, Tom was being very, very respectful, which is a good thing. How are you interpreting this? And they told me I had to go across the street. Thank you. So thank you all. All of you. We have almost 500 of you watching right now. And I want to do a shout out to all of you. But what's happening is that the Commonwealth now wants to change after they're almost going to rest their case. Remember, they're going to have Aperture on. This is what's going to their people, Aperture. Their accident reconstruction people who were hired really because of they were supposed to rebut ARCA, but ARCA's rebutting them, right? And their original triggering report is now changing. They had a triggering report for the Karen Reed SUVs is anything. Acceleration, the computer being turned on, the car being turned on, et cetera, like that, occurring at, and this is important, and we're going to try to get Olivia on sometime tonight, at 12:31:38, right? 4 seconds later, they say John O'Keefe was hit by Karen Reed. But they're now trying to change that record, right? Because they say that this triggering event is what's important, but that they had it wrong because the time on John O'Keefe's phone was wrong. So they want to move the triggering event to a different time. So let's go through it. It's called the key cycle. And if you go to either Olivia Lambeau or Joe Flipperhead on Twitter, they have it all explained. They have it all set out. So let's see if we can explain what it means. And the question is the judge going to allow them to change the report in the middle of this? Joe, and I'm going to talk to you with Joe Flipperhead because he had very detailed analysis. Using the stream, along with the Lexus's black box, it's Karen's, Aperture crash reconstruction experts, that's the experts for the Commonwealth, wrote a report. In that report, they claimed, based on information from the Lexus black box, that the time Karen started her ignition, that the triggering event that's listed in the black box is 1162-2 happened at 12:31:38 to 12:31:43. This means that Aperture believes Karen Reed struck John O'Keefe with her SUV between 12:31:38 and 12:31:43. Now, on April 28th, Ian Whiffen, remember Mr. Wiffleball, testified for the Commonwealth. During his testimony, he stated that John O'Keefe's phone data showed 12:31:56, 12:32:16, and he was interacting with his phone. So he couldn't be interacting with his phone and being struck. And he says that Ian Whiffen said that 12:32:16, there's no more interactions with the phone, but that somebody had to manually turn off that phone with the last interaction. But that means that this is why seconds count, that John O'Keefe was still alive, interacting with his phone when Aperture already had him being hit and being struck by the phone, right? So it can't be. And the defense is pounding on that, and has been pounding on the difference. And then when you compare the two reports, you'll see that 13 seconds after Aperture claims John O'Keefe was struck, Whiffen claims John O'Keefe began interacting with his phone, right? And looking at his phone, and then having to have a manual turnoff. So since the medical examiner testified that the blow to the back of the head would mean that John O'Keefe would have been incapacitated, it would be impossible for O'Keefe to have been on his phone at 12:31:56, based on the time of the collision from Aperture, which was 12:31:43. So you get that. So Aperture has the triggering event and then the collision occurring before before John O'Keefe his phone was still being interacted on. He was still alive. Okay. Now they want to go and change that, just like they changed their whole idea with regard to Cellbrite, right? Aperture that wants to amend the report in the middle of the trial. They did an updated report that they served on May 8th. They served it on the defense May 11th. They claimed that the clocks on John O'Keefe's phone and the clocks on the Lexus are off. Okay, that John O'Keefe's phone runs late, so that his phone, when it says one thing, it's not in sync with what the testimony with Whiffen. So to remedy the issue, they want to fix the clock differences and say that John O'Keefe's phone was running late, and therefore that indeed it was the triggering event, was at the same time that Ian Whiffen, or at the exact time Ian Whiffen says the phone was last interacted with. Okay, so in the first trial, they said, by the way, this interaction occurred at 12:45. Remember, Jen McCabe looked out the window. She sees 12:45, right? She sees 12:45, right? And also remember, Karen Reed connected to John O'Keefe's Wi-Fi at One Meadows at 12:36. So there's no way. The more you move it back, there's no way for Karen Reed to get there, and that's why, by the way, I believe Hank Brennan was trying to say, when does the router extend out? So Karen Reed could have hooked into John O'Keefe's Wi-Fi as earlier than when she pulled into his driveway or his house. Okay, so that's what happens, and that the whole first trial was being testified to. The defense prepares a trial based on this. They have experts, including the FBI experts, based on this. And now, when they've absolutely demolished the prosecution here with regard to the time of the impact, what the prosecution was saying was the triggering event and the time of the impact, and it couldn't happen because John O'Keefe had to be alive. That's what they want to do. And you heard Judge Canonia say all these machinations. Well, who's going to testify first in Aperture? Could you possibly move him to later? No, we couldn't do that. Well, Mr. Leslie, could you tell us whether you could be ready to rebut that, maybe what your position is? I think they have to, in my view, okay, because we had this happen. Dizzy said Gorina testified it was 300 feet that she would have hooked into John O'Keefe's Wi-Fi. Okay, we'll see. But I'm like Walter Amber. I mean, I when I go to our country house, it may be about 20 feet that I hook into Wi-Fi. I don't hook into it because I have a very strong router at the country house, extremely strong. We have everything because of all we do that's on the internet and all. So yeah, the triggering event they want to say is the ignition turn on instead of anything else too, because the triggering event could be anything that the computer records in the car, and they don't record all of the information, the black box. They just record some kind of event, but not all of the information that with regard to it. All right, so that's what's going on here. And we had that expected that after we had a very strong hung, we understood it to be 7-5 in our favor. The judge, sua sponte, said he was going to recharge the jury with a new theory of the case that we never tried, that we never actually tried against, and invited us to have a separate new closing. And we said, no, we're not doing that. We're not having a closing. We object to your recharging. If you want to recharge, you do it on your own, Your Honor, but we're objecting to it, and we're not going to reclose on this, right? And we still hung on to our hung jury there. All right. So it really was, I think that the defense has to hang on to it no matter what she says. I think they have to object to it. I think they have to say that, and they may not want a mistrial, because then that gives the Commonwealth time. I think the Commonwealth may want a mistrial, right? Because that gives them time to have the report into evidence if the judge doesn't allow it in this time. And I think they're looking for a mistrial if they can't get this report in. So they put the defense kind of in a box, because the defense may, to protect the record, have to ask for a mistrial, but they don't really want a mistrial, right? So then maybe they don't ask for a mistrial. There's the fan. Joe Schmo said, devil's advocate, should the jury decide if 30 seconds is relevant to the credibility of the expert witnesses in the report? I think no. I think when you're dealing with experts, it may be once you get it in, but here the issue is the constitutional issue of due process, and unless he's talking about a Rule 14 violation. Because you're now changing your whole theory of the case after the defense has tried the case to your one theory. Now, I have no faith that Judge Cannoni is not going to let this in and let them do it and say, well, you'll have time to rebut, and if you need an extra few days, I'll give you an extra few days, okay? Because I'm going to let them go in because, we've had this testimony now, and all the information's been there. They're just reinterpreting it differently. And I think she's going to let it in, okay? And I think it's absolute, let me just use a legal term, bullshit, all right? And we can, depending on what she does, we can do a little bit of a rant at lunchtime. But this whole idea now to change, this is the ballpark, because then what happens, Joshua, if the jury believes that this new report is right, then the whole defense that they've been doing to show that all of this is wrong goes down the tubes, and it becomes a real problem, and a real unfairness problem, and a real constitutional due process issue for Hank Brennan. And I think he held this, right. I think he held this because this would have come up as early as Ian Whiffen. So I think the report may have not been necessarily put together, but they knew what they were going to do here. Once they knew that the defense had killed Ian Whiffen, and I don't mean killed I mean in a figurative matter, because they showed that the interaction of John O'Kee actually turning his phone off had to be likely after he made those steps that would put him into the house in 34 Fairview. So this is a really big issue. And we're going to hear, I think, some fireworks in the courtroom here. You saw that Alan Jackson went up to Leslie when he was trying to argue. And I know what Alan Jackson said, that, we've tried this case without object, just like what I'm telling you. And that's what's going. But, the judge is back.
You
now.
are unmuted.
Tom is back, but court is back. So let's go into court and let's
So
listen.
I need to see counsel at sidebar, please.
What? Let's go back into court and listen to the fact that she needs to see counsel at sidebar, please. So it wasn't counsel asking. She's asking. This is obviously it's about what she's going to do here. So even though we saw the argument yesterday, maybe we won't see the argument today. All right. Hardman apparently said that they can only be on the registry of deeds side. That's garbage, all right? But that's something that the plaintiffs and Mark Randazza are going to have to do, because basically you could be anywhere in that zone as long as you're not interfering. So they made a decision that anybody who doesn't have a press or media pass can only be across the street, which is a lot closer than it was, right? Right. But thank you very much for getting that and listening to that. A lot closer than it was. And obviously he probably has that conversation. Hopefully, I don't know if he has it on tape, but the whole order was basically you could be anywhere. You could be holding a sign anywhere as long as it doesn't interfere with justice. It's not your intent to interfere with justice. You can be holding a camera, filming. What is wrong with filming the defense team coming in? As long as you're not obstructing how they come in. And you see, if you watched any of the Diddy yesterday in federal court in New York, and then federal court, I can tell you it's kind of a big deal in New York, right? They have the stanchions, like the silver barriers that we see on the side where people come out of the courthouse and get into their cars. And then all the press and everybody is standing right around there, watching. It's a very, if you want to call that a buffer zone, which they don't really have, right? You could see that everyone's allowed because it's a public sidewalk. And so what they've done is they've cleared an area, and then you can't go over these stanchions for that area. A very small area. You walk out of a store, and here's your stanchions, and everybody who's been in the trial going, except for the jury goes in a different way, walks through there, and you don't need a buffer zone, and you certainly don't need people to stay right across the street. Unless it's a very serious security issue. Like, as I said, when they had Donald Trump down here, the press could get in, actually Center Street, everybody else was around. But you could be right around Center Street, including sitting in the park that's right there across the street from the courthouse. And it was actually a smaller street than is here, a very tiny street, Center Street is, in case anyone's ever been there. But it's ridiculous. But we're glad that Tom CPU did go ask, because then that sets the parameters of what the Commonwealth is doing. Now, who decided that? That's how it's going to be interpreted. I don't know. Okay, so Scott, you're in our chat. Good morning. It's up to now. Aiden, excuse me. Daisy says Jess Machado is in Aiden's hearing now. She says his trial is June 9th. June 9th. Okay, so that may be before this whole. I'm just going to write that down. Aiden's trial June 9th. That may be before even the Karen Reed case ends, likely, right? Well, we're thinking that the Commonwealth has at least next week for their case. The defense has 2 weeks after. Well, maybe it's close, charging to the jury and the jury deliberating and all. We'll see. That's interesting, Law nerd Amber, let me just tell you that it's very common in most trials. The family is never there for the medical examiner's testimony. No, they're just not. It's usually, matter of fact, even when the medical examiner, if they're there beforehand, comes in, they pick the person assigned to them, the victim witness advocate type bit or victim advocate, actually come in and take them out. Scott McGinnis, we're waiting the results of this morning's meeting between the state police, DA, and judge. Yes, because how Hardman is interpreting this is still wrong, in my opinion. But Mark Randazzo is the lawyer for Michael Bryant and for Tommy CPUs and for the first protesters, and that's where this case was actually decided. But Randazzo did answer Justice Serve TV's tweet publicly. Does that mean that that CPU Tommy and Michael Bryant win? And that he said yes. Okay, yes. Okay, so it looks like we're going up to the fan. Everybody was standing. Does that mean the jury is coming in? So that was a very quick sidebar. If that was the sidebar on this very important issue about allowing Aperture to amend its reports in the middle of the trial to try to conform with another witness's testimony. Again, like Celebrate. Every time the defense does something that shows that the Commonwealth theory is wrong, they amend their stuff. Oh, they're being amended. So the jury is coming in. Welcher and Burgess are the ones that are for Aperture. Welcher and Burgess, and apparently Burgess has to testify first. That's what they said yesterday. But they're the Aperture experts for the Commonwealth in this case. But you can't tell me that this wasn't held and all. And even getting the report of the 11th, if this judge says something like, well, you've had it since the 11th, why didn't you make your objection earlier? That would be also garbage. You see that Alessi's been preparing and been there and doing all of the work this week on the forensic areas, and he's very precise, and he comes with receipts I think I said yesterday there was only one area that I faulted him on, one question that I thought that he didn't need to ask, and it was a little bit of a self-inflicted wound. But other than that, his whole discrediting of the Commonwealth future expert was great. And remember, the medical examiner testified there's no evidence of a car strike. And Hank, despite going up there and the judge allowing him to recite all this hearsay that's been disputed, did you know that she knew everything but the fact that Jen McCabe had made the statement and all, and it still didn't change her opinion, okay? And we also had a very interesting picture. You remember Connor Keefe? He said he was the only one who was at the autopsy. Well, two troopers signed in, Trooper Connor, of which apparently there is none that we know of, and Trooper Keefe. And it'd be very easy for the defense to find out. And when you see the picture, people are suggesting that that is Michael Proctor that is at the autopsy, because remember, he was up in the Cape Cod area, if I recall, at that time, all right? And he's the one who called the medical examiner a whack job. And she knows that, and she knows. Do you think that she was going to change her testimony after knowing that? Do you think that? Absolutely not. Absolutely not. And she held to that testimony. And it seems to me, as long as, really, quite frankly, if there's no car strike, and it's their experts saying it, this case really should have been dismissed, right? This case should have been dismissed. And Lamont Pickett says, I remember saying he was at the autopsy in trial 1. Putting that out. Well, that's not what they're saying now. They're saying that he wasn't there, right? They're saying that he wasn't there. So it's just Trooper Keefe. So, what is it? What is the reality here? What is the story, right? Yes, I did marry. See, Hank slammed down his laptop yesterday. Hank was pretty upset yesterday because, Alessi really did push the ME on a lot of different things. And he got the fact that what she may be interpreting as hypothermia was really damage from the machine used to do chest compressions, right? Damage to the machine to use what's called the Lucas machines, to use chest compressions. Compressions themselves, by the way, to bring somebody back to life, are very violent. Cracked ribs, and we had those here. You can get all sorts of internal damage. And the Lucas machine is 100 compressions per minute, and just incredible damage there, incredible damage. And so that she could be misinterpreting. That was the only area that he talked to her about. And she kind of agreed the Lucas machine could cause damage, but she didn't know how many times it had been used on him. And the reason why this is happening is because the medical examiner, forensic pathologist that the defense has hired is going to come in and say that there was no signs of hypothermia because there was no signs of tissue damage like frostbite that people get, or any tissue damage of being outside. So that while he may have been found in the snow, and the medical examiner, by the way, did do this. She said, look, this is a situation that had I, though, not known that he was found in the snow, I would not be able to say hypothermia was the contributing cause. And quite frankly, at one point she said, if I did not have the back of the head blunt impact, I could not say hypothermia was the cause of death. She did say that. She absolutely said that. She put it as contributing here because she has a real cause of death with the blunt impact. So that the contributing to the cause of death she felt was hypothermia, but that if she didn't have the original one, she would not put hypothermia as the sole cause of death. That's huge. I accept that's huge. Okay, huge. Okay, that and the fact that there's no collision, no indication of an impact at all. Doesn't matter what people say. That's why you do autopsies, right? You do autopsies to see if who's got it right, eyewitness or this eyewitness. Okay, I'm going to be quiet now. Let's go back into court and let's listen and let's see if we can glean what happened, or if we're going to go right to a witness. I'll go behind my Tubi avatar, but I'm right here.
Good morning again, counsel. Good morning again, Ms. Reed.
Good morning, jurors. So, I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that, and out of respect to the lawyers who worked so hard to get this case before. Okay, thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please? Thank you. Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant in the above captioned matter. Both parties respectfully stipulate to the following. The 2 Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scordi-Bello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Thank you.
And what?
Yes, thank you.
Well, we just
With
talked
that, Your
about
Honor,
that.
I'd like to
So those are the
introduce and
2
play clip
troopers
number
that they've
21.
agreed to, because I'm sure the defense looked at it. So let's look at
Hold on
clip
1 second,
21.
please. I just want that.
Well, hold on, but that was a really big thing. The judges told the jurors not to make any comments under the breath, no facial mannerisms, no nothing. Something must have happened. We're going to be on it, but let's listen to the clip.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
So we need this marked.
Yes, we have the item.
Exhibit 169.
Mr. Lally, you're next.
Your Honor, the Commonwealth calls Andre Porto to the stand.
Well, while that person's coming in, this was a big deal. The judge. So I want to know what exactly happened here. Now, of course, we just heard that there's a stipulation, which means both parties agreed that that trooper was Watson, not Proctor. Okay, but I want to know what happened. That a juror was either said something, made a face, did something that the judge told the jurors to be careful how they're reacting in the courtroom. What was the reaction? Okay.
Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic scientist too in the DNA unit at the Massachusetts State Police Crime Lab.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a Forensic Scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a Forensic Scientist 1?
Sure. So a Forensic Scientist 1 is a training position where we're hired and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a Forensic Scientist 2.
And so you're currently a Forensic Scientist 2, is that correct?
Correct.
And what is the difference between a Forensic Scientist 1 and a Forensic Scientist 2?
So a Forensic Scientist 2 is just the automatic promotion that you get after a year of hire and passing the initial competency test. And we're able to do the DNA process in casework samples.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and no samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where we target specific areas of the DNA to make millions of copies of it. And then we run it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI, National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please.
Sorry.
Please.
Sorry.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Sure. So there are various steps. One step to prevent contamination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now, with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process for the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
And Can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is able to demonstrates ongoing competency in the DNA analysis process. And successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are. We each have 2 copies of our DNA, one that we inherit from mom and one that we inherit from dad. And that this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is, if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats, and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the source of that profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use. And that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or a forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA, and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And there was a known standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct.
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analysts that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's one from one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you use the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number. And the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted, make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the court's permission, this is a little detail as far as the testimony goes.
I don't have a problem. Does the defense object?
I do not object.
Okay, thank you.
Thank you, Your Honor.
So the license plate was 3G6684. Right, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, so sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what does that mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 non-alien, How many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yeah, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the tail light. And the DNA profile was, if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Now, are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have 2 copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodhi Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodhi.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that I didn't detect any human DNA. So there might be DNA on there, but it was below what our instrumentation could detect.
Now, turning your attention to item 3-2.1.1, what is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1, what is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those jeans belong to?
John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now, turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same jeans as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B on the upper right leg of the jeans of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you're referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item stain C to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Now, with each of those items that you just testified about as far as the jeans, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA profile from that item from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir, that number, as far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 nonillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item?
Sample from stain F on top front of gray long sleeve shirt.
And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last four samples from those items, were you able to generate a DNA profile with respect to each of those four?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those four items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoot, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And item 7-18.6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you generate a profile from that item as well?
Yes.
And what is the description associated with that?
Sample from stain H1 on back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long sleeve shirt.
And item 7-18.11.1, what is the description associated with that?
Sample from stain I on back right shoulder of gray long sleeve shirt.
And item 7-18.12.1, what is the description associated with that?
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group, sir, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various areas on the gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange t-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparative analysis of each of the DNA profiles from those items to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originating from a single contributor. The DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions respectively for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left hand fingernail clippings of Mr. O'Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on. May I, Your Honor?
Yes. Let's see if Mr. Yannetti can slow
morning,
this
sir.
down and get some points made.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 3-3.1, which is sampled from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, you found that there were 3 contributors of DNA to that taillight attached to the vehicle, correct?
Correct.
One of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included into the profile.
With regard to the other 2 contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1. Do you see that in your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other 2 contributors?
I don't know. They could be anybody.
Were you ever asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Now, with regard to 7.2 7.1.2.1, or maybe it's 7-1.2.1. That's the stain A from the upper right leg of the jeans?
Correct.
All right. And you were aware, or you were told that those were the jeans that John O'Keefe was wearing on the morning in question when he was found?
Based on the sample description, that's what it seems.
All right. And it turned out that his DNA was on his own jeans, correct?
He was included in the profile
All
from
right.
that
And
item.
that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report?
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's genes, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans, 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1. And if I can just put my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
stain D? Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay. Right. With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.6.
7-1.6.1. Thank you, sir. Okay, now, with regard to the unstained area of the exterior of the jeans, do you see item 7-1.7.1?
Yes.
You found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there to that unstained area of the jeans?
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes?
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir. I'm not trying to make this any more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger's side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least 5 contributors.
And when you have interpreted it as at least 5 contributors, what does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now, moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpreted it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpreted it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on the upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not. Oh,
sorry.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustain to that.
I may have one moment, Judge.
Yes.
So remember I told you when you have a theme in a trial, you ask those questions that go to your theme. This is an excellent cross-examination by Yannetti of a very honest witness. I know it may seem boring on DNA, but what is he doing? He's making the point about all the mixtures on the clothing.
I just have one more. question
of
for you,
John
Mr. Porto,
O'Keefe.
and I do
Let's
want
go
to thank
back and
you for
listen
answering
to
all my
Yannetti.
questions here
Be
today.
right back.
You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the.
Unbelievable. Who he sent his reports to is objectionable. Unbelievable.
Yes.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side tail light of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side tail light, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion?
The DNA profile from this item is 510 non-alien times more likely to have it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown unrelated individuals.
Now, Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange t-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13 different items, they're all from a single contributor, is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange t-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison?
Objection. He's already testified to. He's not supposed to retestify.
So the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
He was included in the profile, correct.
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustain.
How many sources were associated with those?
Objection.
Sustain.
Nothing further.
Okay. You all set, Mr. Yannetti?
That's because he was just re-asking his direct.
Thank you very much.
All right. Well, one thing we can say is this is an honest witness, right? I mean, he's just telling it like it is. Let's hear the.
Call Ashley Valier to stand.
All right, let's talk about this. The cross was excellent. You have a lot of mixtures there, and they were never asked to compare the mixtures against any DNA, nor were they asked to compare, I see, the mixtures against each other. In other words, if you're getting a mixture and you're getting profiles of a mixture, were the other unknown profiles that were in the stains, were they the same profiles in the, let's say, the 5 stains they talked about on the sweatshirt, or the contributors to the upper insole of the sneaker? Okay.
I do.
All right, so I'm going to let you listen to this witness. We'll talk more, obviously, on the break. And I'll answer that question about the
All right,
objection.
Mr. Lally,
to
whenever
Proctor.
you're
I think it was totally
Thank you, Your
ridiculous
Honor.
to object to
Morning,
that.
Ms. Valier.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Valier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master's degree in biomedical forensic sciences from Boston University.
Now, following your education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And what did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace, arson, and explosives unit. So we analyze a wide range of pieces of evidence. So trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers fire debris evidence, and explosives covers explosives.
Now, specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how is that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a single item. Generally, you look at the questioned item first, the item that you don't know specifically where it came from. Look at that, and then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
We have evidence storage locations at the laboratory.
And how are they typically packaged when you receive them?
They can be packaged in cardboard boxes, brown paper bags, heat sealed plastic bags. It depends on the individual items.
And when you're doing this analysis, as far as the physical match analysis, what do you do to your bench between your examination of separately packaged items?
I mean, before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper.
And why do you do that?
To make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Would that include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
Stereo zoom microscope is a microscope that's mounted on a stand. So it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point, were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned to do in this case?
I was asked to do physical match analysis, and then later on I was asked to look at, do some trace recovery, look at some debris.
Starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10.
Several, fair to say?
Yes.
Okay. And how are each of those items packaged when you receive them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times. When you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The question items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with a list of just the item numbers first to start with?
May I?
You have your report with you, Ms. Willett?
I do.
Okay. Is there any objection, Mr. Nady, to using the report?
No objection at all.
So feel free to use it.
Thank you, Your
Honor. So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Valier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you label those specifically in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at, I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually. Inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Your Honor, may I approach?
Yes.
And Your Honor, so the court, so I've shown Mr. Yannetti all the photos in advance.
Is there an objection to any of them,
There is
Mr.
no
Mayor?
objection, Your Honor.
All right, so why don't we just go ahead and mark them all as evidence?
Your Honor, if I could, I was going to take them item by item.
Okay, that's fine. Okay.
Ms. Blair, I'm showing you 4 photographs. You recognize those?
I do.
What do you recognize those to be?
These are photos that I took of item 3-1.
Again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further give sort of a specific vehicle or license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
On the Commonwealth will seek to introduce in a minute the next exhibit A through D.
Right, those are covered. That's why I wanted to just mark them all because they're all covered. Right?
That's fine. If the court prefers, I can provide them.
All right.
Exhibits 170A through 170D.
May I approach with the remainder, Your Honor?
Yes. If you have them in sections, we can do that.
This way I'm showing you 2 more photographs. Just ask if you recognize those.
I do.
And what do you recognize those?
Photos I took of item 7-5.
And again, from your report, what was the description in reference to item 7-1?
Yeah.
Thank you. You're fine. It's just
Okay. Piece of plastic red recovered from 34 Fairview Road.
And you're on the Commonwealth seek to introduce and admit as the next exhibit A and B.
Okay.
Exhibit 171A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those?
Yes.
photos to the jury? Ms. Gilman, if I could first ask for photograph 2122. And Ms. Blair, what's up on the screen, that is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Valier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table that you would clean with the solution and everything else, correct?
Yes.
Okay. And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Lear, if you could just describe for the jury, what are we looking at in this photograph?
Those are those same items just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Lear, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We'll need 2 more photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-6.
That's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
Your Honor, Commonwealth will seek to introduce in the minutes the next exhibit A and B.
172 A and B.
With the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921 and then photograph 1924. And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you. May I approach the witness again, Your Honor?
Yes.
Two other photographs. Can you review those? Can you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag. Is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Commonwealth seek to introduce in the minutes the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes. Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please. And Ms. Lair, again, what are we looking at in this photograph of item 7 dash? What are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
Two other photographs. Those. Can you recognize those?
I do.
And what do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag. Is that correct?
Yes.
So 7-9 and 7-19 were contained in the same bag.
They were. I then separated them into 2 separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item, black straw, recovered from 34 Fairview Road.
Your Honor, will seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
174A and 174B. Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please. And then 1962. And again, Ms. Lear, what are we looking at in this photograph?
The contents of that bag, item 7-9 and item 7-19.
May I approach again, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
A piece of plastic, red, recovered from 34 Fairview Road.
I want to seek to introduce and admit as the next exhibit, A and B.
Exhibits 175A and B.
May I publish that for the jury, Your Honor?
Yes.
Ms. Gilman, if I could have 1952. And 1956. And again, Ms. Lear, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
And again, one photo of the bag and one photo of the items outside of the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with item 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
I'll call both to seek to introduce and admit as the next exhibit, A and B.
Exhibit 176A and B.
And may I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982. Again, Ms. Lear, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves. And Ms. Lear, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Two other photos, you could look at those. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-12.
And again, photograph of the bag, photograph of the items outside of the bag.
Yes.
And if you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
Now, the Commonwealth seek to introduce and admit as the next exhibit, A and B.
Exhibits 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Lear, again, can you describe what's depicted up on the screen?
A photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'm going to seek to introduce in the minutes next exhibit A and B.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Ms. Gilman, 1997. And 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you. And Ms. Villiers, directing your attention to the screen, can you describe for the jury what is depicted on the screen now?
A photo I took of item 7-13.
May I approach the witness, Your Honor?
Yes.
Two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the item removed from the bag.
Yes.
And again, can you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce the next exhibit, A and B.
Exhibits 179A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2009 and 2012. And again, Ms. Gilman, if you could zoom in on the item. And Ms. Villiers, as far as what's depicted on the screen, again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
Other photographs, if you could recognize those.
I do.
And what do you recognize that?
Photos of item 7-15.
And again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
Commonwealth seeks to introduce in a minute as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2072.
Yes.
Yes.
And 2077, please. Again, if you could zoom just a little as far as the items are concerned. And Ms. Villiers, what are we looking at in this photograph?
Item 7-15.
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm also seeking to introduce the minutes of the next exhibit, A and B.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Ms. Villiers, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down. Now, With respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And Your Honor, if the witness may refer to her notes as to, thank you.
Yes, four of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled, and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic red recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
And when you say no physical match found from the different pieces within that item, what does that mean?
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item 7-5, correct?
Yes.
Okay. Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road. What did you conclude based on your physical match analysis just pertaining to that item 7-6?
So this item was 2 pieces of colorless apparent plastic, and there was no physical match noted between those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match. It's just one piece, correct?
Correct.
Okay. And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So that item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly, for this purpose, item 7-16, a piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item, 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Valier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
That's perfect. Yes, Your Honor.
All right, jurors, we'll take our morning break. We'll see you back here in about 15, 20 minutes. Thanks for where you can walk out right with the jurors. And can I see counsel for a minute, please?
All right, we have a morning break. I'm wondering whether she's going to do anything in open court. She's going to see counsel. Now, she is the person, we know, we've seen her testimony from the first trial. All right, that these pieces put together, and she taped some of these pieces together and all. And, you know, they're going to be from the scene where she found them, and some are a little missing little edges. But that doesn't answer the question of whether or not there was a car strike, that these came apart from John O'Keefe, and how they got to 34 Fairview, right? There's some little pieces that are missing. And so you're still, even if we find these all come together, that there comes the question: no, there's no blood on any of the housing for the taillights, none at all. All right. And, you know, you saw John O'Keefe's arm. If indeed the prosecution, the Commonwealth theory is right, that she nicked him in the knee, he had to get those scrapes and abrasions linear on the arm from somehow the tail light fracturing, shattering, exploding out into his arm, right? Now, I want to go back, though, before we discuss her testimony, which is not finished. And, you know, it's you know, luckily, all I can say is we slowed down here, right, with this witness from the previous witness on the DNA, who, you know, was, I mean, I think he was nervous as could be, you know, and he was just there to give the stains and the DNA and the testing and all that type of stuff, right? So I just want to go back to some questions that were answered. And it's just basically the same question. I need to know why Judge Canoni didn't allow the answer. And Linda, why was that not sustainable? Is that irrelevant? And what we're talking about is at the very end of the DNA analyst, right, who testified. Again, he's moved to a DNA analyst too, Mr. Porter. Yannetti, who did an excellent cross-examination, pointing out that the samples of very important things, such as the sneaker, the orange T-shirt, and all, that there was mixtures, right? That there was mixtures on contributors to mixtures in the DNA that was found on very important things. At the very end, there's a report that he's actually working off, Mr. Porter, when he testified, he's working off his report. And he said, "Who did you send your report to?" Objection, sustained. And Yannetti, of course, followed up. Did you, because he wants the jury to hear it, did you send your report to Michael Proctor? Objection, sustained. And then the judge said to disregard what they've heard. Now, I think that should have been allowed in, because the fact that he is sending his report to Proctor is, to me, is important. That Proctor knows what's on this report, that he's involved in every part of this investigation. So what could be the reasons that the judge sustained it, besides bias, okay? Besides not allowing things that go into normal trials getting allowed here? You could say it was beyond the scope of the direct examination. That's the first thing, because the direct examination only limited itself to the report. But my suggestion would be that that's not right, because the report that he's talking about, whether it be on DNA or not, also would indicate who was the submitting agency and then who gets the report that he sent to. All right. The next portion could be on relevance.
All right, Ms. Gillespie, I'll hear you.
Okay, let's go.
You
Let's
are
go into court.
unmuted.
We'll talk about this later.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. We, and that's a significant point. I know I don't need to elucidate for Your Honor. It goes, all of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just never, no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is we have on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we crossed, we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
Yeah.
Okay.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed.
This is disgusting.
Also, it has
This is
been
disgusting.
clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believe that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a 3-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of any.
Their expert made an improper conclusion. You're changing your theory.
She thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorga. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Go right ahead, Mr. Leslie. The only question I had for you yesterday, for you to respond to today was the time, so I gave you more leeway.
And
So
you're giving me more leeway, and I appreciate it.
go right ahead.
So, two items,
Excuse me,
Your
she
Honor.
gave him more than she'd asked for?
Yesterday in-
This is a huge issue.
A point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum, there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline. In his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I
Brennan?
appreciate the clarification.
I'm not sure what he's saying, so.
It sounds like DeBrosia or whatever,
His name is DeSogra, yes.
DeSoder. You're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher.
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which addressed all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments. Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been. Other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the report, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is
Yes,
correct.
and I'm happy to any information.
Thank you.
All
Change.
20 minutes.
No.
right, thank you.
All right, for the court, please.
Okay, this is ridiculous. Okay, both Hank Brennan and Judge Beverly Cannoni. This is ridiculous. Hank Brennan getting up there and saying that the defense is confused, okay? And then saying the Commonwealth has not changed any of their opinions. Well, if they haven't changed any of their opinions and timelines, why are they getting a new report from this expert, Mr. Burgess, who apparently has to testify in front of Judson Welcher, okay? And Alessi makes a great point here. He says the Commonwealth said, well, this report just came out of the blue. Remember when the bill from ARCA came out and the judge had grave concerns? Well, apparently she has no grave concerns here that somebody apparently, and Alessi is absolutely right, may have been told or may have violated the sequestration order. We're talking about this case with somebody, because why out of the blue would he do a report that changes the basis of their timeline to look at John O'Keefe's phone and the ways off his phone, his Apple iPhone, compared to the infotainment system that's on the Lexus? That didn't come out of the blue. They have changed the theory all the time. And instead of saying to, as some judges would say, those with sneakers, shall I say, I'm not allowing this in. It would delay everything. It shifts the burden of proof because you're actually going to bring somebody in. He told us about bringing somebody in rebuttal now. It would delay us, and it would also affect. It's embedded, quite frankly, in how we have tried this case. And if now they bring in a new witness and say, oh, look at the defense tried this case different way, and now we, Commonwealth, have a new theory about the timeline and why the defense is, our timeline is now shifted and all the defense told you is gobbledygook garbage, it affects Karen Reed's right to due process and a fair trial. This is outrageous. This is outrageous. I wanted to do a rant, but I think I'm already ranting, okay? This is simply outrageous. I wanted to talk to you a little bit about what happened in the courtroom with the woman who puts together puzzles for a living. You know, very nice. All right, she's in the lab, the physical lab. She's putting together the tail light and showing what piece is missing. But it's irrelevant because the question is how the tail light got to where the tail light was to begin with, right? It's all irrelevant. So I don't want to spend too much time on her. So why don't we go through? Yes, Lizzie says a professional puzzler. Why don't we go through this and let us all together rant together, okay? I don't even want the music on this at this point. It is outrageous when a judge of a court will allow the prosecutor to come in when they're almost finished their case, when the defense has gone halfway through their case on cross-examination to establish their theories. So when their witnesses come in, the theories fit right into their cross-examination, to now come before the court and say, we are not only giving you a new report, one, by the way, we allegedly didn't ask for, one, by the way, that was done because apparently somebody has violated the sequestration order, and the judge doesn't apparently want to even give a voir dire to the defense, right? If this, just imagine if we turn this around, and they now want to change their timeline to move it back so that the differential, because they did, despite what Hank Brennan is saying. And I'm sorry, all right? You may be a good attorney, but you're lying in court. And I'm going to call you that. You're lying in court. To say you're not changing your theory, you're lying into court. To say you're coming in with no new knowledge here, no new facts, you're lying in court. And you know you've got a judge who will allow it, because everyone in that courtroom wants to get Karen Read, not on actual real testimony and good testimony, but on testimony that appears to have problems in it, right? They want to try to always get around the medical examiner, get around this, get around that. It's outrageous. You know, Hank Brennan did this yesterday, slammed his computer. Well, I am slamming my computer, okay? I am slamming my computer, because that's not how this should run. So let's go through why it's so important here, all right? And why the defense did what I think they should do, and say it's embedded in how we've tried this case. I wouldn't have even given her answer on 4 days. I would have said, no, you can have a judge. I'm sorry, we don't have an answer for that, because we cannot remedy what you're trying to do here. So we are going to, if you let us go forward, it doesn't matter whether you give us 2 days, 4 days, 1 month, or whatever. It has affected how Karen Read has gotten a trial. She's now going to get a constitutionally defective trial. She's not going to get due process. And it is, as Candace NP says, as I'm seeing it come through, it is a disgrace. Dizzy, I don't know why they gave her an option. I don't know why they gave her an option, okay? And you're right. She's going to give them, let's say today is Friday, Monday, Tuesday. She's going to tell them that you can't call Welcher maybe until Monday or maybe Tuesday and all. But this is outrageous, because here's what it was. And I'm going to refer you to both Olivia Lambos on both Twitter, Twitter, and Joe Flipperhead also had a breakdown on this, okay? All right? This is ridiculous. The Karen Read's Lexus showed what they call a triggering event. Now, what is a triggering event? It could be an ignition being turned on. It could be acceleration. It could be almost anything. But the Commonwealth is taking that ignition, triggering event, to be where the Lexus, they say, traveled 62 feet at 24.2 miles an hour. That's what they did in the first trial. I don't know if they're going to do it in the second trial, because that was based on Trooper Paul, right? Quite frankly, let's just stop right there. You've all seen the scene and where she parked. She couldn't get up to 24.2 miles an hour in 62 feet there, 24 miles an hour, and hit John O'Keefe. She was parked, according to them, like, you know, in front of the front door. And that's only about 50 miles an hour. So what they're going to have to say is what? She went back to the other house, and then she came forward and did a 3-point turn. That is ridiculous. Okay, so the triggering event to them is when Karen Read hits John O'Keefe now, all right? That's what they were saying, even though a triggering event could be a lot of other things. But the Commonwealth is limiting to when she hits John O'Keefe, okay? using Aperture, which they used initially. They wrote their report here that said the black box time that Karen started her ignition it coincided and affected the triggering event, and that was between 12:31:38 and 12:31:43. I think Mr. Alessi just misspoke. He actually said 12:31:42, but it's actually 43. If you look at all the previous reports, so you have that 3, 4, 5 second interval there. In that time, supposedly that's when Karen Reed struck John O'Keefe. Okay, then comes the new trial. Ian Whiffin comes in from Celebrate. Remember, there's all sorts of issues with regards to Celebrate. Okay, that's in terms of rewriting software and all to eliminate something that's exculpatory to Karen Reed. But Ian Whiffin comes in and testifies for the Commonwealth and is cross-examined, obviously. But during his testimony, he states that the cell phone data from John O'Keefe shows that he was interacting with his phone at 12:32:16. If John O'Keefe is alive, interacting with his phone at 12:32:16, he couldn't have been hit dead, immediately incapacitated between 12:31:38 and 12:31:43, right? So right there, that was like ball game over for the Commonwealth. The defense wins because their own witness had him, John O'Keefe, alive, actually manually shutting down his phone, like we shut down our iPhones, right? You click that button on the side, actually shutting down his iPhone at that. Win. There, that's a win right there. And by the way, when Hank Brennan opened, that's what he opened with. Now, I know what the attorneys say is not evidence, but that's what he opened with if you want to say that wasn't their theory. Okay? So, as the conclusion for that was, when you compare the reports, you see that 13 seconds after Aperture claims that John O'Keefe was struck, all right, that's at the most 12:31:43, right? Because it's between 38 and 43. Whiffin claims John O'Keefe began interacting with his phone at 12:31:56. So you see that supposedly, and that's what everyone keeps saying, seconds matter. Hopefully at the end, the defense is going to put all that up. Seconds matter. So once Whiffin testified, that was game over for the Commonwealth, right? Simply game over, right? And then, since the medical examiner has testified that the wound to the back, and I think the defense medical examiner is going to testify too, would have left O'Keefe incapacitated, he couldn't have been on his phone interacting with it at 12:31:56, right? All right. So the time of the collision by Whiffin and the original crash report by Aperture, which used Whiffin's information, is very clear. So now, what has happened? All of a sudden, supposedly out of the blue, when we know this is game over with that, especially game over when you have the fact that the medical examiner testified there's no indication of impact injuries on any of John O'Keefe's body, right? Which, by the way, the Commonwealth is trying to get around, or will say that the bruise on the right knee of John O'Keefe was somehow caused by the impact that somehow shattered. By the way, all this stuff somehow shattered. John O'Keefe shattered that taillight into all those pieces you see. And interestingly enough, none of those pieces and those red pieces of polycarbonate plastic of sort end up in John O'Keefe, right? It really is game over. The prosecution can't prove the case beyond a reasonable doubt, even for those people that think this is just a Dewey case with a hit and run. You got to prove the hit and run, and you got to prove the person is dead after the hit and runs, and she's charged with manslaughter and she's charged with murder. So here they come. So now they decide to, just like they decided to come in and have the Cellbrite software rewritten to help them, because it takes away a fact that shows that there's an exculpatory evidence and not guilty. Amazingly enough, now all of a sudden you have Burgess come in and say, well, the problem here is that there's clock differences, that John O'Keefe's phone, and we went back to Waze with Apple. Waze works off the Apple timeline, and that there's a it's called monotime difference versus actual display time difference, and that really that there's a difference between that, and there's a difference between the Lexus and infotainment center, the black box. And because of that difference, they want to now put the triggering event at 12:32:16. Okay. And if they put it at 12:32:16, that's past 12:31:56. I hope I'm going slow enough. You're getting all this, right? Yeah. So 12:31:56. So they now want to put this. They now want to put. I understand Burgess's out of the blue. I didn't, know the violation of any sequestration order. Just happened to go back and decide to relook at all their data that they've had that's been given in discovery that everyone has worked off of, and put the fact that the collision was actually at 12:32:16, which would be after the time that John O'Keefe was alive, according to Whiffen, or after the time he last interacted with his phone at 12:32 at 12. I'm sorry. Yes, at 12:31:56. Okay. So there you have it. I mean, if I were trying this case right now, I'd have a chart for you. All right. But that's it. So that when we keep saying seconds matter, the defense says seconds matter. They tried this case knowing that the Commonwealth couldn't sustain its burden because they had John O'Keefe live walking into the house. Now, I'm not sure there's still an issue, because the later that the triggering event happens, which the collision supposedly is at now 12:32:16. All right. We know that on 12:36, Karen Reed interacted at One Meadows. Could she have gotten home in a snowstorm? Supposedly, according to the Commonwealth, it was blinding snow, even though it wasn't. There was snow on the ground. All right. So also the fact that she was driving, if you recall, very slowly. She said she drives slowly when she drinks. Understandable, but that is supported by Whiffen's testimony. That is supported by it, because it showed her going, I think, 20 miles an hour at the highest, or 21 when she drove from the Waterfall Bar to the 34 Fairview. So she has to then get back to her house. Let's say all of you, if she cooks in at 12:36, right? And she has to get back if the accident is at 12:32:16, right? She has to get back in like under 4 minutes, right? From that house to her house. And the Commonwealth is already trying to say, well, she didn't have to get to the house. All she had to do was get it within the time that the router was able to pick up her phone. Because the router has it could pick up the phone on the Wi-Fi, not when you're driving into the driveway. Unlike my house in the country, it does have to pick it up when you're driving into the driveway and standing almost right in front of the house. And I think you have to be in the driveway for the Wi-Fi to pick up. And I have a very strong router. Okay. Very strong router. They want to have it like 200 feet, right? 200. I've seen 300 feet. I've seen 50 feet, so that they can put her out more of a football field out and say, yeah, she could have gotten to this location from there in under 4 minutes. That's what they're doing, because Commonwealth needs to extend that time because they have a problem on that end. They have a problem on this back end, right? I don't know if they can do that at all. So now maybe the defense is doing this. The defense could ask for a mistrial to preserve Karen Reed's right, but they don't really want a mistrial. And I'll tell you why. They don't want the mistrial because then in the next trial, this stuff does come in, because it's not stuff that's, this report does come in. It's not delayed. It's not late. It doesn't affect how they tried the case, etc. So defense does not want a mistrial, even if they ask for it. Okay. They simply don't want a mistrial. Now, maybe what they're doing is they know that, Judge Beverly Cannoni is going to let it in, okay? Because you've got those indications already, all right? She wouldn't have had this. When she said something to the effect, well, Mr. Lester, I only asked you to give me the answer to one question, but I let you go on with other stuff. Let him go on. This is the major issue of constitutional proportions in your trial, and you want to disdain him by saying, I let you go on? Are you effing kidding me? Okay. Are you kidding me here? All right. This is outrageous. And she should be saying it's outrageous. And you know that if the defense did this right now, there would be grave concerns. Okay. The disparity of how she's treating the prosecutor and the disparity of how she's treating the defense is un-effing believable. All right. Un-effing believable. And let me tell you, she's thought of so well up there, she's probably going to go to the Massachusetts Supreme or their Supreme Court. All right. This is ridiculously unbelievable. So maybe what the defense is doing, okay, we want to ask for 4 days. We'll get the weekend. We'll try to get a way to cross-examine Burgess. We'll try to get information that he violated a sequestration order. Then what is she going to do then? Okay, give them a slap on the wrist, because she's not going to do anything, even if he did violate the sequestration order. She'll say something like, "Oh, I let experts talk to other experts." Well, she didn't do it in this case. She didn't grab that order in this case, right? And then they're going to lay the trap, because they know that maybe perhaps they want to bring in this information after ARCA presents their situation. So maybe they want to talk to ARCA about how they head this off at the pass, and then show to the jury and how many times the Commonwealth has changed their opinion. Now, they can't go and say, "Ladies and gentlemen, Hank Brennan opened to you that this accident occurred between 12:31:38 and 12:31:43. They can't say that, right? Because what an attorney says in opening is not evidence. They can do that, by the way, at closings. They can say, "Let me tell you what the Commonwealth said they were going to prove. Did they prove this? No, they changed their opinion." They can do that, but they can't use it in terms of a cross-examination in a trial of either Burgess or the other expert, Judge Welcher. Okay, so that's where we are. All right, so they're going to have to find a way, the defense, because the judge is going to let this in. Need some jazz. Can they file an interlocutory appeal of some kind if she does allow this? Yeah, they could, but it won't be successful, because the court will wait and see whether or not there's a conviction, and they'll say, well, if there's a conviction, she has a remedy. Judges, it's very hard to get an interlocutory appeal granted on this type of issue. All right, they will give the judge wide latitude, and they will wait and see. Well, maybe it's not like you say, defense, because if there's a not guilty verdict, the problem you have is if there is a guilty verdict, all this bad stuff that together is all disgusting, but individually may not meet some type of standard, right? To knock like the prosecutors off the case, it is hard on an appellate. It's hard when you're dealing with an appeal issues, right? When you have to have an omnibus reason for overturning the trial, it's hard to get that. It's better to have something that's actually a complete constitutional violation. I think this is an absolute complete constitutional violation. I think this, for them to go forward after the defense is ridiculous. So Laura McLeod asked the same question. If Bev allows, should they request a mistrial? What recourse does Karen have if she denies a mistrial? So we know that could they take an interlocutory writ? It's not called a writ there, but an interlocutory appeal. Yes, you have to get permission to bring it. And then what if the higher court allows this to go forward? I mean, it's almost like giving the Commonwealth and Hank Brennan a pat on their head. And quite frankly, I wouldn't trust any court right now with how this is going on. If I am the defense, I am completely not at my wit's end, but I feel really, you'd feel more committed, right? Feel more committed, right? Scott McGinnis says, by the way, hi, Scott. Scott, you're in here looking like the court's ending for the day soon. Well, they have to, I think they're going to finish with regard to this witness who's on the stand, right? But I don't think if indeed I think that there has to be, I think you should bring Burgess right now. Let's do a hearing on him. All right, let's do a hearing on him, why he's changing his opinion right now. Sua sponte, we've heard that before. Like yesterday, remember when Maureen Hart got up? Sua sponte, she wanted to correct something, right? I see the fan running. Thank you for the fan for taking your time, because I hope I've laid this out right. If not, you can go to Olivia Lambo. She has this all laid out, what I have talked to you about. And then also to Joe Flipperhead, that's FKR 102445 on Twitter. They have this all laid out also. But this is a big deal. And I'm going to say it in legal terms. This is a big fucking deal. All right. All right. Now, you know that I don't like to curse, but I do like to curse when I think that the justice system is being hijacked by improper rulings, and certainly by improper allegations. And while I have said Hank Brennan is a good lawyer, I think he's over the top when he accuses the defense of being confused. We now have, according to him, confusion software, confusion defense. No, what we have is a prosecution that wants to get Karen Read at all costs. And by the way, you know, the jurors apparently are very interested in what's been going on in the courtroom, except for the fact they did get yelled at, and we were going to play this at lunch. They didn't get really yelled at. We have the admonition. Apparently 3 jurors are giggling sometimes in their sidebars. Now, I've seen jurors lean over in sidebars and kind of talk to each other and giggle, and sometimes they even talk to each other. Why? Because they're at sidebar. You know, they can't talk about the case. They have already formed relationships. I can tell you right now, having tried a number of cases, if you know, especially the ones that sit next to each other, they kind of look here, they look here, and you see them, right? You see them. Okay, it's actually ridiculous. It's actually ridiculous and all. So we put up there the timeline according to Hank. All right, that we had up there. I don't know if there's a way that we can post it separately. Maybe we can post it separately to our X account, right? But this was the timeline according to Hank that he was responding to, and we had it up there. But I wanted to read you the specific times because seconds matter here. Thank you, Disney. Thank you very much. Michael says they're trauma bonded. Yeah, they especially the ones that sit next to each other. And I've seen it in cases all the time. And sometimes you actually kind of like smile at them if you're right next to them, or they're looking at you. You know, this is a hard thing to sit there all day on those hard chairs listening to sometimes really boring testimony. Okay. And sometimes because of such boring testimony, the stuff that was really important, which was yesterday, which actually should be game over no matter what. Even if this gets in, I still think it's game over. How do you have a car accident that kills somebody when your medical examiner says that there's no indication of any car strike? None, zippo, zilch. And then, of course, you had the DNA person, which we really didn't talk too much about. Yannetti was great, showing that there's all mixtures. Now, they didn't test against who those mixtures are. They weren't asked to test against anybody. We know that they had, a Proctor and Buchanan's DNA, but they weren't asked to test against anyone else because they probably didn't have the DNA of anybody else. So that's really good for the defense. What I wanted to know too, when I read the reports, are the unknowns, because you can see through the weight of the DNA who the unknowns are that they're not calling. Is the unknowns that they're filing, do they have the alleles on them? And those alleles on the unknowns, that's how you look at DNA, whether, you know, you end up with these great statistics with the various alleles on DNA. Do they show that they're the same alleles on each of these stains, the sneaker, the pants, the top? Because doesn't that help an argument that if it's the same 3 people in the mixtures, and one mixture was 5 people, right? There was 5 people, but it's the same 3 people in the mixtures, John O'Keefe and 2 others, and you have a defense that says that 2 other people did this, their third-party culprit defense. Then if those same alleles are in all the mixtures, to me, that would be important. I don't know if they actually gave the alleles for the mixtures, because mixtures are very hard to separate the alleles. What you get is a chart where you get the these various different alleles, and that's how you look at it. And they said there's a mixture because they could tell that maybe one of the alleles may be different, you know, one of what's comprising it. If I could find a DNA chart that I have from another case, I'll show you and put it up to show you what I'm talking about. So to me, that would be very, very important. But I don't think that's how this DNA was done. This new way they do DNA, it's more likely to be John O'Keefe because it's a mixture, but he's likely to be in the mixture because of probably the weight of the testimony and the amount of the alleles, the weight of the DNA and the amount of the alleles that are there. But you know, so to me, that's very important. And I think Yannetti made the point. You didn't test it. You didn't have Higgins. You didn't have Albert. And then on those pieces, so she talked about, you didn't have the chief, right? You didn't have there was the chief and there was somebody else that she mentioned. on whether or not those alleles. Matter of fact, you didn't even test them against Buchanan, remember? Because one of those little pieces, the chief supposedly called Buchanan out, and he came back and got it. And you did have his DNA, okay? And you didn't test it against that. So they basically didn't test anything except against John O'Keefe's DNA. And that's not the analyst's fault. He is just told to test to see whether or not with the reference sample that is submitted, and that would be John O'Keefe, with the reference sample that is submitted, that whether or not that reference sample matches John O'Keefe. And he came up with yes, and of course you expect to find it on his clothes. But on all these other locations, you had a number of mixtures or contributors. 3.211 was the back broken drinking glass, 712.1, upper right leg jeans. Then you had at least 3 contributors. Then you had 3 contributors and another stain. Then you had 2 contributors and another stain. You had 3 contributors and another stain. You had 2 contributors and another stain. You had 4 contributors on another stain. On the sneaker, you had 5 contributors to DNA. Okay, so and then there was also a stain on the bottom long sleeve that was 2 contributors. 2 contributors on another stain, and 5 contributors on the upper right stain. So it doesn't really matter where these are from. On John O'Keefe's clothes, let's exclude for the moment the glass, okay, which had the glass, the alleged drinking glass, which had 3 contributors. You had at least 1, 2, 3, 4. 1, 2. Let's see. Let me go backwards. 1, 2, 3, 4, 5, 6, 7, 8. 9 stains that were analyzed that had more than John O'Keefe's DNA. And that's important, that the stains that were analyzed. And one of them wasn't even a stain. One was just a sampling from the gene, and it still had 3 people's DNA. And why is that important? Because that's just not on you know, the stain or the blood or whatever. This is actually embedded into that one, into the DNA, into the gene. And so you all know have genes. It's pretty hard to, you know, get something embedded into the that type of fabric. So that's where we are with that. So Yannetti was very good. I assume that they will then do what I do, which is add up all the different locations that had stains on them, or didn't have stains but had DNA mixtures of more than John O'Keefe. To show that it's on his long sleeve shirt, it's on his regular shirt, it's on his sneaker, it's on his jeans, and so that these all had various mixtures. And then that one piece of drinking glass, they didn't test anybody. They didn't test for Chief Berkowitz or for any of the Alberts on that drinking glass. That's what I had down, okay, for that drinking glass, which had 3 contributors, the way I wrote it down, okay. So there was, but it came across. Here was his points. You weren't asked to test for anybody else. On the light, you weren't asked for test for Chief Berkowitz or the glass, if it was from the light or was it from a regular drinking glass. You weren't asked for test for Chief Berkowitz or the Alberts. For everybody else on these 11 other stains that were on John O'Keefe's clothes, you had either mixtures of John O'Keefe which with other people, between 2 and 5 other people, and you didn't know who they were from. But you know they're mixtures of at least 5 other people. And with the 5 people, you couldn't even tell whether or not, whether it was John O'Keefe or not. Why? Because it was their protocol in the lab is not to do it when you have so many mixtures, because you can't tell if you're getting it right because of the weight. And maybe there's so many alleles that cross over to each other. So that really, I think, came across. Now, all the jury has to write down is mixtures on John O'Keefe's clothes, not tested for DNA. That's all the jury needs to write down, right? That's what they need to write down. Mixtures from John O'Keefe's clothes, unknown DNA contributors, not tested, and all. That's what he needs to write down. And of course, they're going to write down, they're going to, in their head, write down the word Michael Proctor, even though they don't really still know, I don't think, the significance of Michael Proctor, the way this case has been tried, put in by the prosecution. So that I thought was pretty good. And with regard to the woman on the stand right now, the criminalist on the stand right now, we are in a situation where She is still, she's from the trace evidence unit. She's doing physical match analysis that is criminalist weir. And we know from the first trial, she's going to put parts of the light together, and there's going to be a little piece missing when she puts it together. But remember, Karen Reed said when she hit the Chevy Traverse, she thinks that when she looked later on, that she thinks she broke a piece of her taillight off, and that one little piece. Not Michael Bryan's, the taillight can go up the arm and act as a dog bite. Notice how the Commonwealth hasn't addressed anything with regard to that, okay? Notice how the Commonwealth hasn't addressed anything with regard to that. So let me see with regard to, I see there's another question here that maybe in my, a couple of questions that I haven't answered in my rants of sorts. Okay. Celeste Palladino, if Commonwealth found, if Karen found not guilty, can case be turned over to FBI and that unknown DNA tested? They surely have Leo prints. Well, the problem is that if it's, we don't know how much has been consumed of that. Remember the hair was consumed when it was tested. And it's hard to retest the DNA unless you have new technologies that wouldn't be able to separate out mixtures. And mixtures are a problem with DNA testing. That's why they do this whole thing. It's, 24 octillion, million, gazillion, bazillion, more likely to be John O'Keefe and 2 other people than it is to be 3 people that are unknown. But as somebody pointed out, what is important is there was male DNA in those mixtures, and it wasn't John O'Keefe. Okay, that I hope the jury got. Micah asks, when there's a material misrepresentation to the court, like Hank is currently lying to the judge, can you file an interlocutory appeal if the judge denies the rule? Just what we talked about, yes, you can. It's not going to be granted, and if it is granted, they'll probably rule against you because they want to. The higher courts like to see if there's a conviction first, because if there's a conviction, well, they never have to deal with this issue. The problem is that if there's a conviction, what's going to happen is Karen Reed is going to go to jail and sit in jail for a very long time. This says I really can't express how serious what is going on in court is right now with regard to this new report and how serious it has affected Karen Reed's due process right to a fair trial right now, because her defense has been based on what the Commonwealth has presented to them in 2 trials now. And now they want to change when they're close to resting. Okay, when they're close to resting and when the defense is close to bringing on their case. It is outrageous. It is disgusting. It should not be allowed. Okay. It's different if the defense had a report. If the defense has a report and it has exculpatory evidence, that is different. But the Commonwealth has a duty to try this case beyond a reasonable and get proof beyond a reasonable doubt with fair evidence, with not being sleazy, with not being slimy, with not being secretive, with not having reports just show up in the middle. This is not just one thing. They've changed a lot of things with regard to this. Remember, they went after their own medical examiner yesterday. They went after their own medical examiner in the beginning. She has held tough and said there's no evidence of a car strike. If there's no car strike, in my opinion, Karen Reed cannot be convicted. If there's no car strike, she can't be convicted. But that doesn't mean she won't be convicted with unfair evidence and the way this case has gone in with the complete Judge Canoni, who, in my opinion, has changed from when she started the trial to now. My opinion about it has changed, and she is allowing this to happen. And it is a modern day, I won't say lynching, that's a different thing, but it's modern day electric chair. I'm going to bring you back into court. I'll be behind Tubi Avatar. Don't worry, I'm not going anywhere. Oh, guess what? Now we're talking. I was going to go behind Tubi, but now we're talking.
All right,
See what's
so
happening there.
Mixed Mayor, I'm going to ask you that you speak right into your microphone when you answer, if you could, please.
Okay.
Thank you. All right, Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Mr. Lear, we talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Ms. Valier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D. So those two pieces were at one time together as a larger unit.
And Ms. Valier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So two pieces from item 7-8, pieces C and D, one piece from item 7-9, piece A, and one piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Valier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially remove the items from those individual bags, place them on the table, and examine them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC 684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
Here I'm showing you 3 additional photographs. You recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Your Honor, Commonwealth, to seek to introduce and admit as the next exhibit A, B, and C.
Is there any objections to any?
No objection, Your Honor. Thank you.
182 A and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms. Villier, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Valier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item. And Ms. Valier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the tail light housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Valier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So there's 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Are there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Right. Mr. Giannetti?
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1?
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long were you made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton? In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17.
Yes.
And the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes, our in-lab chain of custody extends from when we receive it to when the submitting agent, it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals. They take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes.
Okay.
All right, my favorite light, and now my favorite fan is on. I didn't hear, was that Hank Brennan, or it was Lally, I guess we asked, may we approach in terms of this, Unetti is making a point about chain of custody in the lab being very good, because obviously if the lab gets garbage in or fails to get garbage in, that happens before with the terrible chain of custody, a non-existent chain of custody, basically. We've seen from the Massachusetts State Police and from Canton. I don't have to go over that with all of you. And so she's a technician. She does what she technically is trained to do. Here, it's putting together these pieces and then looking at the fact that there was debris package, and she checked it, but she wasn't aware whether or not the clothing was all put together in a bag prior, and whether or not there was any three people's debris on the tail light that she was looking at. So Unetti is using her to make points.
Having reviewed your reports,
we're going back.
Can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Were you aware of the date
Singer,
of the incident
Michael Proctor,
that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the
Yikes.
lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period? Do you know if he had access to pieces of red or clear taillight during that 6-week period?
Sustained. Move on, Mr. Unetti.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Unetti. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lally, or are you all set? I'm not curbing it.
Mr. Lear, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
Okay. As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right. All set. All right, so jurors, that is it for today. I'm told when I spoke with counsel earlier that we are still on track. I have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
Yeah.
Well, Scotty's reports that he hears that they're going to be ending early seems to have come up, right? I wonder what's going on, quite frankly, and whether it has to do with what happened in court. We'll wait for a second to see if she comes back and discusses anything. But we have a number of things to discuss.
So
Let's hear about
before we
this.
recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated and what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies, the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
Okay, we have a lot to discuss. This is normally the lunch break. We have a lot to discuss. I want to discuss this right off the bat. And I will say to you, this is still outrageous, okay? It is absolutely outrageous. This after there were full argument on a report that's being, that came out of the blue, supposedly, by one of the defense experts, Mr. Burgess, who supposedly testified before Welcher. That's the aperture experts for the Commonwealth, who after trial number 1 and trial number 2, as we almost near the end, probably let next week be the last week, likely of the Commonwealth's expert witnesses on the stand, because there's not many left, right? That she is going to allow this testimony to come in. And what is it? And we'll talk about what it is again. And here's what she reports. She is not persuaded by Mr. Alessi or the defense, basically, that this is a surprise, that it's not a surprise. Well, then what is it? Okay. Or prejudice. If it's not prejudice, what do you call it? A walk in the park, a pina colada on the beach, maybe with a little straw umbrella in it? Come on. It is a surprise and it's prejudicial. And she didn't find, by the way, she didn't make findings of fact. And I think that they got to go back and ask her and writing to make findings of fact about why she says it's not a surprise and why she says it's not prejudicial, when the defense has laid out why it's prejudicial and why it is a surprise. In addition to that, she is not even going to allow, okay, Mr. Burgess, expert Burgess, okay, to have a voir dire or on the issue of his new report, which supposedly came out of the blue. No grave concerns here, okay? However, she will give Mr. Alessi a lot of leeway in asking questions, and she says, you know what Neil Rockheim, when he was on, he said, this is what judges do. They allow the prosecutors to do this, and the judges always do say, oh, pat on the back. Oh, pat on the back. You are so good, Miss Kenny Bodden, at what you do. I know that you can handle this because you are a great attorney, which is what she just did to Alessi. Oh, you've shown a facility here of having a complete understanding of the facts, and I know that you will do a terrific cross-examination. But after the direct examination, Mr. Alessi, should you feel that you need more time to prepare, I'll hear you on that. Not that she said she'd give it to him. I will hear you on that. And by the way, the same thing she did in the first trial. Should you feel that you need to recall Jen McCabe, I'll hear you on that. Well, the last thing, after you've destroyed witnesses, you don't want to recall them, okay, to have them rehabilitate themselves. And can you imagine if the jury then gets left without cross-examination immediately of Mr. Welcher? So Alessi has to be prepared. It is an outrage. It is wrong. It is a violation, in my opinion, of the Constitution, her right, Karen Reed's right to due process, okay? It is simply terrible. And yet, there is a double standard in this courtroom, right? There's a double standard because had the defense done anything close to this, and we've seen, according to her grave concerns about getting a bail after a trial ended, that it has affected how she treats the defense in front of the jury. And one of the reasons I think Mr. Alessi is taking on more of the work is that they're saving Alan Jackson for the really big witnesses and also limiting his exposure to Judge Beverly Cannoni, because when she's up there, she shows her disdain, okay? I can't, and I use the F word today because, as I said, sometimes it is the only word to describe what is going on. And I will say it here, the defense is getting royally fucked, okay? This is an outrage. Now, Why is it an outrage? Let's go back to why it is an outrage, okay? All right. And we have a number of things to talk about. So just stay with me. Let's keep staying with me here. Remember, at the first trial and here, and when Hank Brennan opened, go back and look at his opening. Maybe if we can find his opening, where he talks about this, we'll try to find it. Diz, maybe we'll try to find it. I think it's a very short, and he talks about what's they call the triggering event. Use plain English. What it is that at certain times, your black box in your automobile, which also controls your infotainment center, we kind of heard about that a little bit. Remember in the Alec Murdaugh case, has an event that happens. They call it a triggering event. And it could be a triggering event is anything that hits the computer for that black box. It could be when a car starts. It could be when a window goes up. It could be when a window goes down, right? It could be when the car door opens. It could be when you accelerate. But it doesn't record everything. It just records some things. But the Commonwealth has suggested that Karen Read started her car and then backed up and went 24.2 miles per hour in 62 feet. And this is what they call the triggering event. At the end of the triggering event, they said that's when John O'Keefe was hit by her car. They have claimed all the way through in all these trials that happened at 12:31:38 to 12:31:43. You can write these down, 12:31:38 to 12:31:43, okay? All right. Dizzy has a different 35 feet forward than 70 feet back. I have it a little different, but it's about the same. Okay. It's a ridiculous statement, quite frankly, given the size and the scope of the of 34 Fairview and where she is supposed to be and where other cars are supposed to be. But that's a triggering event, and it ends at 12:31:43. And the case has been tried since the beginning of the defense case, ladies and gentlemen. That seconds matter in this case. Even Jennifer McCabe, who at her first trial said that she looked out and saw Karen Read was there at 12:45, and therefore that's when the Commonwealth was saying then that must have happened there. Even though we know that Karen Read hooked into John O'Keefe's Wi-Fi at One Meadows at 12:36. Firm, clear, undisputed right now, except for the fact that the Commonwealth may say she hooked into it not when she went into the driveway of the house, but she hooked into it 200 feet before, with no, with some kind of statement about what the range of the Wi-Fi router is, without knowing what the range is that night in a snowstorm, et cetera, et cetera, et cetera. Okay, you and I know we see Michael Bryant with our Starlink, and in the clouds it doesn't work, right? Okay. Okay, Dizzy said that came from Hank's opening directly word for word. Okay, so I trust Dizzy. She is one of the best. Okay, so that it would be that if 35, I'm going to amend my notes, 35 feet, right? Let's deal with that. She drove 35 feet forward and then back 70 feet, right? Back 70 feet. Okay, and I think it was still I don't know if he had 24 miles per hour, but that Trooper Paul had her at 24.2 miles per hour. That is definitely in the first notes, right? So let's deal with that. The trigger event was important. So then on April 28th, come to you Ian Whiffen, who I have called Mr. Wiffleball, right? Ian Whiffen, who uses his own software, and he does a number of things. One, he uses his own software, and he says, that he takes away the Cellbrite analysis from the Cellbrite extraction that shows that Jen McCabe served Hustle to Die in the Cold at 2:27, right? a.m., right? And that it was deleted, even though Axiom and all the other people still show it. So he writes a special software program that removes it from Cellbrite, okay? Removes exculpatory evidence to help the prosecution. Cellbrite is one of their biggest, one of the biggest clients in Norfolk County would be obviously the DA's office, because Cellbrite's used basically by prosecutors at all. It's at all to do extractions. Private people generally don't buy Cellbrite. All right. So he comes. Not only does he remove that, okay, trying to put that in doubt, and the defense has to deal with that, but at least they knew that was coming because there was a report beforehand and they were ready for it. He then testifies that when he looks at John O'Keefe's extraction data, it shows that from 12/31/56 to 12/32/16, John O'Keefe was interacting with his phone, looking at messages, and then actually had to hit the side button to close it down, right? Looking at his phone, hitting messages, and then closing the side button down, which, by the way, usually you'd be doing when you get inside the house, not outside in a court, as the Commonwealth would say, in a blinding snowstorm, whiteout conditions, as they were saying. You're not necessarily looking at that, but they have them looking at that was game over at that point. Why? Because the triggering event, according to the Commonwealth, when in the last two trials and what the defense is prepared for, ended at 12/31/43. So remember that. So it ended. John O'Keefe was alive for another, another almost minute, according to this. So triggering event 12/31/43 ends supposedly with the impact with John O'Keefe, but then John O'Keefe is on his phone to 12/32/16. All right, then he's on his phone to 12/32/16. All right, so that's the end. That should have been the end of their case right there, because the triggering event, which is what they're considering the impact, was before John O'Keefe was ever off his phone. He was still alive, well, probably walking into the house. Remember those big white circle that Ian Whiffen didn't want to initially show, to show that John O'Keefe had gone into the house? All right, so that's what you have, and so you see that John O'Keefe was still alive for at least 13 seconds, more than that, before he supposedly was hit by Karen Reed. All right, and we know that he wasn't like walking around in the snow looking at his messages and closing his phone, because at the time whatever did impact the back of his head would have left him incapacitated. Okay, so here we go. We're going all through this trial. You've had cross-examination of Jen McCabe. You had cross-examination of Whiffen. You have your experts. You prepared your experts. You're ready to go. You know that you have totally demolished Hank Brennan's opening as to when this happened. And all of a sudden, I guess somebody says from the Commonwealth, hey, not only do we have a problem with the fact that there's a medical examiner that won't call this a homicide, even though we have all these alleged statements by Karen Reed, which I don't believe. Okay, I can believe she said, "Did I hit him? Could I have hit him?" I don't believe any of the statements that she said. I hit him. I hit him. I hit him. I hit him. Him. I hit him. I hit him. I hit him. Hit him. I don't believe any of that. Okay, I don't believe any of that. All right, at all. And I'm like a juror. Okay. But she said on one of those clips that we saw, the reason why she started questioning is because Jen McCabe, who was with her, said, well, John never came into the house. So then she said, could I have hit him? Did I hit him? Could I have hit him? Right? Did I hit him? Question mark. Or trying to wonder out what's going on if he never came into the house. And when I saw that clip, that put that really in perspective to me, because it was because of Jen McCabe saying that she started wondering what the hell is going on with regard to this. Okay, because McCabe had told her both on the phone earlier, and then that he didn't come into the house. He never came into the house. Remember, she called Jen McCabe to find out what the heck was going on. That's why you heard all that screaming with the daughter, with the guardianship daughter, the former niece there. So now comes the Commonwealth, and on May 8th, they get a new report from Mr. Burgess from Aperture, and it now has a different timestamp that apparently the reconstructionist, Mr. Welcher, Judson Welcher, has got to testify to, which now claims that they're going to amend the report, and they're going to say that the triggering event, which they say is the impact of the collision with John O'Keefe by Karen Reed's car, is now 12/32/16. Is now 12/32/16. Okay. Okay. All right. So was at the collision, so that John O'Keefe, got off his phone, and immediately when he hit the button, the end button, he was immediately collided on with that car. Okay. So so there we go. Actually, I'm sorry, I misspoke. So 12/32/16. Okay, 12/32/16. Okay. So that John O'Keefe got off his phone, and then the collision happened, kind of almost a simultaneously impact. So it's garbage. It's garbage. And why are they saying that? Because they're going to talk about something they call monotone time, right? They're going to say it's different time, and that the Apple phone, they took the phone, they took Waze, and they took the time from Waze, which uses Apple, and that's a monotone phone time and not display time. And that when you go to the Lexus, it has a different uses a different time system, so the times are mismatched, and they have to use put the time forward that they had from the Karen Reed triggering event. They got to put it forward to match the time period on the phone, or backward, whichever way you want to say it, whether they want to, but they've got to make the mesh, right? They have to make the mesh. And this is just ridiculous because, Whiffen testified that the phone was being used at 12:31:56 after the time that triggering event happened. So now they have to change the times on the phone to say John O'Keefe's phone was off by seconds, and it was off by actually 3 minutes, I think they're going to say. And therefore, with their first analysis, it was always there. They just didn't see it, right? They just didn't see it. Well, why are they seeing it now? Are they seeing it now because they realized that there was a problem, that they had a problem? So now they're going to, just like Celbright's going to rewrite their software, they're going to now rewrite the reports and now have different conclusions. Okay. Now, I am telling you that when you get this far into a trial, usually no one allows you to amend your report like this. But she's finding that it's not a surprise because the data was there. What do you mean the data was there? Data wasn't there. There were no reports on that data. And then secondly, and most importantly, and most ridiculously, that there's no prejudice to the defense because despite the fact that they've tried the case, despite the fact that they've gotten all this far along, if you need time, Mr. Alessi, after the direct examination, I'll give you time. She won't even allow a voir dire of this man, Burgess, to see why it is that a sua sponte, on his own, he sends this report, okay? She won't even allow that. That's going to be done, that voir dire, you know when that's going to be done? In front of the jury in open court. So the defense doesn't even know how they are going to really be able to cross-examine, unless he's going to have to be on his toes and is going to have to be able to be facile with information like Alan Jackson actually is facile with information that he gets from a witness. Alessi, as you know, has everything planned. So he's going to have a lot of different things planned to deal with this. Because then when Burgess gets up and testifies to that, then they're going to reinforce it by the aperture. This is how they plan to end. They plan to bring Burgess. They plan to bring Welcher. And then they plan to bring the gamma ray guy, I believe. Or they plan to bring the gamma ray guy from Florida in first. And these are their big, strong endings. And actually, and what did Hank Brennan say that was ridiculous? He said, well, we may want to use this in rebuttal. This report is in response to ACCA being wrong. That's what he says. This report's in response to ACCA being wrong. We may want to use it in rebuttal because ACCA's wrong. That's why we did this. And the way I love it, I'm imitating when he says ACCA, right? It's in response to ARCA being wrong. ARCA gives him a bug up his tush, right? Right? His boxer shorts are tied in a knot, okay, on this with ARCA, all right? So it's absolutely outrageous. It's ridiculous. And again, all she does is, oh, you're so good, Mr. Alessi, you can deal with it. Karen Reed has a constitutional right for a fair trial. She has a due process, Sixth Amendment right for a fair trial. She has a due process right. It applies to the states. And in my opinion, this is a total violation. Okay. Now, sometimes when you get these things, it ends up working to your advantage as a defense. You can show how they've changed the report, how they may have listened to what's going on, how they knew the testimony was bad. And, the jury may find, because they're younger and they're kind of savvy, that things can be kind of moved around and changed around and all. And they may not trust these experts, okay? So it's absolutely ridiculous, okay? And I'll guarantee you, if ARCA comes back with a report that says that this is bad and tells you why, you know what Judge Bevel will say? Rule 14 violation. surprise to the prosecution, prejudicial to the prosecution. Okay, that's what she'll say. Okay, because that's what she's going to say. You know that, and I know that. Okay, it blows my mind. It makes me sick to my stomach that I'm involved even in covering a case like this, and I can't imagine how the attorneys feel and how their clients feel. Okay, so let's go off this for a second. Let's just mention to the fact quickly on the testimony this morning. The important part of the testimony was really the cross-examination, that there's a lot of mixtures of DNA on John O'Keefe's clothes, and there's mixtures of DNA on the back housing of that taillight. Okay, going right into the defense's theory about third-party culpability, which the judge may not allow. She may not, does not allow, because every time they get to a question about Brian Albert's DNA being tested, there's an objection and it's usually sustained. I think only once did allow it. So that's where we are on that. Now, I want to go back to the buffer zone, all right, because things are happening with regard to the buffer zone. All right, and we're going to report exclusively what happened this morning. As you know, we were covering the buffer zone this morning and all. And after we do this, by the way, we're going to talk about what's happening with the jury. But first, the buffer zone, and then we're going to get into the jury about what's happening. Okay. Joey Kane gifted 5 memberships again. You know, Joey is so great because you see when people get them in the mail and they will, they're so excited to get them and all. And thank you all for doing that. You really are fabulous for helping us. And by the way, before I get into the 2 exclusives that we're going to have right now, please all hit that like button. If you're watching from Twitter, come on over to YouTube, our YouTube channel at Justice Served TV, and subscribe. It doesn't cost you anything, and hit our like button. Okay, it really is important to all this community that's been growing here for the last 5-6 months with us, mainly watching this trial, watching a Young Thug. We've actually had 3 trials that we've covered in depth. Young Thug, Doug Weinstein has been on, as you know. We had Rocky. ASAP Rocky, and we had a number of exclusive with ASAP Rocky that have dealt with Joe Tacopino, who was on, who gave us his first interview after he had the the not guilty verdict, even before TMZ. You know, so it was actually it was before I was waiting for the jury verdict. It was amazing to us, and we had 3 different exclusives on that case and all. And this is the 3rd case we're covering in depth, as we've really decided to start this back in September, and then kind of getting our feet wet and figuring how we're doing it, and with our great mods and great help, and just all of you with the gifted memberships. I'm trying to put them up as I'm talking. I'm not being so successful. Joey Kane gifted 4 totally. Donnie, not Donnie, gifted 1. Shy Gal, let's see if I'm doing this correctly. Donnie, just Donnie, right? Just Donnie gifted a Justice Served TV membership, and Shy Gal also gifted 1. Thank you all for your generosity here, and all the generosity all week that you have all shown different people like Madeira Beach Caregiver and all. And I'm getting a lot of emails at Justice Served TV, giving us your thoughts and stuff to cover, and some analysis that we actually have used, and we try to give you credit, and we try to respond even if we're a little late, because a lot of stuff is going on here. All right, Kevin, new member, thank you very much. So again, hit that like button, hit the subscribe button, and if you're on Twitter watching us, please come over. So let's go through what has happened with the buffer zone. Now, you know, Michael Bryant, with Justice Served TV, he's one of the 2 plaintiffs in the first 3 suits that were filed, right, against Judge Beverly Cannoni and the Commonwealth of Massachusetts and the state police, right? First 3 suits. He felt it was very important. We were on the air right when the case started, and by the way, he'll be there. He'll be there next Tuesday and Wednesday. We understand a lot of other people are going to be there next Tuesday and Wednesday, and the buffer zone. And we actually sued. The cases were separated, even though Mark Randazzo, great lawyer, Center for Liberty, who took on these cases, won. The First Circuit said, this buffer zone, you can't stop people from quietly protesting or even just expressing their opinion in a buffer zone like this, as long as they don't do it with any intent to disrupt proceedings and obstruct justice in any way. You didn't do the right thing. So the opinion came down. The court gave her 2 days, which she took all 2 days to try to redo her opinion, and she put in that as long as you're not impeding the sidewalks, impeding people, and and she put in the intent aspect that must be in there. But she left the scope of the buffer zone the same way. So this morning, we were covering CPU Tom DeRosier, who's Michael Bryant's co-plaintiff in the suit, because Michael Bryant, I was on the air, I covered them. They were walking through, they were doing, trying to get some press interviews, they're walking with Scott, and with Mr. Delgado kind of shows up. As they're walking through, Scott's going to go to get the bagel shop, and Michael Bryant's trying to figure out what's happening on and asking people as he's walking through. And the trooper says to Michael Bryant, I don't know what that is that's making that noise. Somebody must be doing some kind of construction here. I apologize if you hear that sound. It says to Michael Bryant, I've seen you walk through here 5 times. I don't want to see you again. And to Tommy DeRosier, they really have, even today, they told him he had to go across the street and he couldn't film certain times when certain people were coming in. Now the jurors, no one's filming the jurors, by the way. And I apologize, that appears to be construction that's going on because I'm here in New York City. So here was New Lines. Remember, we had Christine Anderson on. She's the bus driver we've had on a number of times, who's been ticketed. She's been harassed. They try to call her job, she says, to get her fired. Let me quote this. So this morning, I don't know, I feel like the fire sirens are coming past here. So this morning I drove by the courthouse and saw Tom. It's Tom DeRosier. He was he was talking to a trooper alongside a woman named, alongside a woman I won't mention, who I did not feel comfortable Tom being near. Although she is a supporter of Karen Reed, she and Tom, they have some toxicity between them. Well, when I saw Tom with her, I gestured, punching by hitting one hand with the other, as if asking Tom if they were fighting, and he shook his head no. Then I had 3 troopers approach my bus and yell at me, claiming that I made that gesture towards the trooper Tom was talking to. They said they were going to charge me, okay? Tom did not even see me make that gesture, so no one did. So clearly these 3 officers were targeting me and watching me. They contacted my employer, and now my boss will not talk to me. And she gave us authority to report on this. This is outrageous. I mean, even if you make a statement like that, okay, even if you do that, all right, what is that? That's not a threat to anybody. It's the threat to nobody, okay? But apparently in this buffer zone, which they still think they have total, complete control over, things like that are happening. So the buffer zone is still an issue up in the air, all right? We'll wait for the opinion on Michael Bryant and Tom DeRosier's case, and the opinion on Mr. Delgado, whose stuff was ripped off. It's like, you take my pin. This actually belongs to my sister, by the way, Joan, who is listening but not on today, but she's listening. And you rip it off. He's got a suit for that. And then you saw what happened to Erica Walsh, who was wearing the microdot sweatshirt the other day. It's outrageous. And apparently, while some things are changing, not everything is changing. People need to train these officers, and they have to stop having paddy wagons and thinking, well, let's put everybody in a paddy wagon. It is ridiculous. It's absolutely ridiculous, okay? Just terrible. Again, we'll try to report this on you. We took the step, our small network took the step of having Michael Bryant file this lawsuit for the First Amendment, okay? You didn't see big CNN out there. You didn't see MSNBC. They were not there. You didn't see any other networks doing it. Our small streaming network. Why? Because we're committed to bringing the truth to you. And sometimes you may not like what we hear. I mean, we have said on this trial that Karen Reed could get convicted of a DWI case with leaving the scene of an accident. She could get convicted. The way Hank Brennan has tried this case, depending on what the jury thinks. And you don't necessarily know what the jury thinks. I shudder sometimes when I listen to jury interviews and all. But which police officers down there? It's the Massachusetts State Police that's running this. And it was Hardman, by the way, who told Tom that he had to go across the street. He was where Karen Reed's coming in, and Michael Bryant's been there with his press pass, not with showing that he's normal press, even though he doesn't have a press pass to go into the courtroom, because they don't recognize YouTube streamers, they don't recognize law tubers as actual reporters, right? We took that step, and that's why people, I think, are so upset with Karen Reed, because they feel with the Sandra Birchmore case, with stuff they're seeing with regard to the buffer zone and what's going on in court, that this is not right. And the court's doing everything they can to limit that. That's why they were these people who were just all they were trying to do. And you saw them. There wasn't even a bruised knee. I had more of a bruised knee when I took a tumble on my heels the other day. I had a bruised knee. I'm fine, by the way. But there's not even a bruised knee for what they're doing out there, what they've been doing out there for 2 trials. It's not exactly like they're it's J6 and they're storming the Capitol. They're standing out there with American flags. American flags, okay? Standing out there with American flags, all right? So anyhow, it's absolutely ridiculous. Sheila said, P, how can this not violate Karen's constitutional rights? I think it absolutely does. I think it's a 6th Amendment violation. I think it's a 14th Amendment violation. I think it absolutely is embedded. What she's doing is embedded into this case. It's a sandbag. If I've ever seen one, it's outrageous, and it's being allowed by the court. Okay, it's like lynchings. Okay, we're allowed by the justice system. I collect old, and you can't get it, hard to get anymore, old time material when the courts were sanctioning people who were lynched or slavery, right? And they would say that there's nothing wrong with owning a slave, okay? And the courts, the owners would go to court to try to make sure that they had the rights to slaves. So I point out that the court system has sanctioned a lot of really bad things along the time, and they're sanctioning this is along with that. Unfortunately, I guess the ghosts of Sacco and Vanzetti, who one of them appears to have been innocent and was executed, remains in that courtroom, okay? Because that's what I believe we have going on here. It is outrageous. All right. So then we have another thing that we can report with regard to the jurors. And as you know, the judge came in with an admonition, and I think we have that admonition to play to the jurors this morning, not just the defense. Dizzy, could we play that? As I know you have it queued up. Okay. I feel like Tubi's ignoring me. Okay, Sassy, while you're doing that. I know we have it queued up with the court admonition to the jurors this morning. Hello, anyone talking to me? No one's speaking to me. All right, let's give it a few seconds, a few minutes here. There we go. It's queued up. I can see it in my little piece. It's going to come.
Good morning again, counsel. Good morning again, Ms. Reed.
Good morning, jurors. So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk. Don't make any facial expressions. No muttering under your breath. No audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that, and out of respect to the lawyers who worked so hard to get this case before. Okay? Thank you very much.
All right. Now, when do you see an admonition to a jury that tells them that it's very important they follow the evidence, even evidence that may have been newly made up, okay? Follow the evidence so that everyone could hear it. No facial expressions, no muttering under your breath at all. When do you ever see it? I think this is the first time I have ever seen a jury who's been admonished by a judge. Okay. And juries usually like the judge. The judge arranges for their meals. The judge gives them a day off. The judge arranges for their transportation. They usually feel very close to the judge. I wonder how they're going to take this. They were admonished. Now, it's being reported, and it has not been confirmed. Initially, it was reported that there was giggling that was going on, and we talked about it early, between 3 jurors during sidebars. And that happens. Jurors form bonds when they sit next to each other. And I've seen jury giggling during sidebars or passing things and all, or they talk to one another and, and all, because they're sitting there waiting sometimes for 20 minutes. All right. As we're at a sidebar. And in this case, I think there's been more sidebars, in the case than there has been testimony in some days. Okay. But it is being reported that, and this is from Harry Carr, and apparently Mark Betterow is also reporting it, that I've noticed Canoni has dramatically changed her demeanor during the last several days, far less hostile to defense attorneys. Well, maybe less hostile, but not more hospitable, that's for sure. A little hesitant to automatically sustain a Commonwealth objection. This information is third hand. So now it's fourth hand to you, but I'm going to give it to you for what it's worth. The word is that the jury sent her a note through a court officer that they wanted her to stop automatically sustaining all the Commonwealth's objections because the jury felt it was unfair, and they wanted to hear the witness answer. The information came from a court officer, hence her change of judicial demeanor. Okay, so that's apparently, according to some reports, as to what has gone on. One of them is that they were giggling, and the other is that they sent her a note. Now, if they did, that would have been dealt with by counsel. That note is marked and it's sealed. All right. If they sent her a note, okay, it would be marked and sealed. Let's see. The court officer was put under oath at sidebar. The officer was given the note from the jury. That's from, let me show that to you. I did not see the court officer being put under oath, but I'd love to get a screenshot of that, or so we can go back and take a look at it and find it, where the court officer was put under oath, or whether or not, because if you're reporting it, you must have seen it. I missed it, if that's the case. Okay. But that certainly would indicate that the jury, and I told you before, juries want to hear what the answer is. They want to know what the answer is. They think when people are objecting, which, by the way, the prosecutor was doing the most objections that had the sustained, sustained. Sometimes the objection was sustained before the question could be gotten out. And even Jackson, if you recall, at one point said, "Judge, I haven't even asked the question." Right. And Brendan was sustained, and Brendan was objecting. And so if that's the case, she's got a bigger problem on her hand. All right. First of all, the jury is not going to necessarily like everything that she says. She's not going to have that close relationship with them that we see with a lot of judges. But secondly, they're trying to listen and follow the case, and they don't want to be interfered with. It's their duty to come up with a burden, whether somebody's guilty of murder beyond a reasonable doubt. And these objections that she sustains, and some of them were even today, I couldn't believe them, are outrageous, are ridiculous, are terrible, are, in my opinion, biased. Now, I'm not attacking her personally. I'm attacking what she's doing in what I believe is wrong under the law. All right. Let's make that clear, because I have a bar license, and I have a duty also to be respectful of her judges. And I've tried to be respectful of her. But when she's wrong, I'm going to call her out. I believe these rulings. I'm calling her out as a journalist. I think she's wrong. I think she's absolutely wrong. And you're dealing with a second retrial. The world is looking at you, and you're dealing with officers who have a lot of problems. So KP would, let me see, KP would have done it for free. KP would have done it for free. I'm going to try to see if we can go back and find that, where an officer is called a sidebar and put under oath, or is that do you know if that was being reported and that happened out of the presence of us, or did it happen? Okay. Let's see. KP, she says, I'll check again. KP says, I'll check again. I believe it was reported by Sue from inside. Sue from Boston would report it. That would be really interesting. That would be really fascinating and really interesting. Please check on that for us. That's great. Micah says apparently they ended early today because Dr. Turk's sentencing is at 2. But they can't handle 2 high-profile situations in the same courthouse. Is that it? Yeah, the jury could think the judge is biased, and the jury may think the system's unfair too. It wasn't on camera, says Dizzy. So if it's being reported that indeed a court officer was brought to the side and put under oath, something then happened, all right? And then, but that note would be under seal. Dizzy said she asked you this morning, but she didn't mention it at all. So we will see, and we're going to be on it, and we will look more for it because we have a show that we will be doing tonight. And actually, it's a real treat of a show with a really great crime scene investigator. And you know her well, Cheryl McCullough, Mac. She's won almost every award you can win. She's solved cold cases. I've been on her podcast recently. She's returning the favor to you to come on our show and answer questions about this case. And I happen to know from being on her podcast recently, she thinks that the evidence collection in this case is not great. Okay. All right. So, but we're going to let her speak for herself. And we're also going to have Lauren Conlon on. She's, I don't know if we've put her, let's see, I'm going to put Lauren Conlon. I'm sorry, I'm reading all of your questions, by the way, and your answers, and I'll go back to some. She's going to be on. She's going to talk about the Diddy case, all right, which is going on right down the street here in Manhattan, you know, where they don't have a 200-foot buffer zone that excludes people. Oh, there goes who's ever doing sawing and renovation here. All right. KP would have done it for free. Dizzy, she reported 9:16 a.m. that the officer is being put under oath, okay? That the officer is being put under oath, okay? Let's see. Yeah, it's true. If he is put under oath, it's because he's telling her something the jury either gave him or something the jury relayed to him orally, right? But quite frankly, Michael says Howard Court take with a grain of salt. What he said, I throw it out to you because that's what's being reported, and we know that something may have been reported. Remember, she asked to see. Remember this morning, normally she says, oh, I apologize for that sound that may be coming through. It's like the fire hydrant. Remember, normally counsel will say, I understand counsel wants to see me. This morning when she got out on the bench, she said, I want to see counsel, all right? I want to see counsel, okay? So it's a different vibe in terms of she's making the direct approach to counsel to come there. So we're going to keep on it. We have great people and great moderators, and all of you. If you know more about this, please email us to at justiceservedtv@gmail.com. So while we take that break between now and when we take the break between now and when we go back on at 6 p.m. For our 6 p.m. wrap-up show with Cheryl McCollum and Lauren Conlon. Yeah, there's our email. You will we'll hopefully have even more answers, and we can look at it. But yes, I agree with you. It looks like the Commonwealth's hiding evidence, especially yesterday, I think, with the medical examiner, right? Especially with the medical examiner. And I have to think that if we're feeling that way, and if you're all feeling that way, it's not because you're necessarily free Karen Reed, even though a lot of you are. It's because make sure the Constitution works, and that if there's a crime to be had here, it's proven beyond a reasonable doubt. But so far, the only person we've seen that anyone has noted that's done anything wrong is former disgraced trooper Michael Proctor, lead investigator, who now the head of the state police, terminated, finding all 2 charges and all 4 of the specifications guilty, okay, were guilty, and terminated him. But, the judge, despite all that, doesn't have grave concerns. The judge, as Michael Bryant would say, the Commonwealth is sandbagging. Judge Beverly Canoni, granted, when the Commonwealth wants to do something that is outrageous, or I'll allow it, okay? Or I will allow it, all right? Well, all right, so I need you to if you want, we're going to have, this will be up. Sheila says, Sheila, as you know, said, how can this violate her rights? I hope we answered your question. I hope we've answered all of your questions. Michael Bryant will be back on Monday, but I will see you tonight and then also on Monday, but I'll absolutely see you tonight. Please, if you have any questions you want answered tonight from Cheryl McCollum or Lauren Conlon, you can put them, actually send them to us, email them to us at justiceservedtv@gmail.com. We'll take a look at them. The show is going to go very fast, so get on right at 6, because I know sometimes you wait, and all people wait. Get on right at 6, because Cheryl's going to be with us, hopefully for at least half an hour, and Lauren's going to be with us, and then I will take any questions and answers that you have. And this is going to be your show to get your questions and answers from two of the best people on the scene. So I hope you've enjoyed Justice Served TV today. Please, before you go, hit that like button, hit that subscribe button, hit that share button, and then hit the notify all button, because you don't want to miss any episodes in case you forget. But the like button helps us, gets us into the algorithm. The subscribe button doesn't cost you anything, really helps us get into the algorithm. And then take a look at memberships. We are very gratefully been gifted memberships by Joey Kane, Shy Gal, Donnie Not Donnie, and we have a new member, Kevin, because Michael Bryant usually posts a lot of different stuff for members there, especially when he goes to Canton or Dedham. He'll post some clips earlier than the public gets to see them, so you'll be in the know. And then also we have some members that have joined our top level who are going to get to have a one-on-one chat with Michael Bryant and I as soon as we can work out between all of us different dates. I thank the moderators, Dizzy and Missy. I thank Oasis Cat for doing all she does. I thank all of you for doing all you do in your fight for justice. But come back and watch us, and we will see you at 6 p.m. tonight. In the meantime, try to do the right thing.
Some